Acharya from the Department of Computer Science and Engineering at IIT Kharagpur, India. I will be
Hello, everyone. Welcome to the 18th International Conference on Artificial Intelligence and Law. My name is Roberto Bornhausen. I'm a member of the local organizing team from University of São Paulo, and this is the fourth panel of the second day of our event. I would like first to present our sponsors. Jus Brasil is currently the #1 law and government website worldwide that makes high-value legal information easy and quick to access. And also our platinum sponsor, Albert Einstein Israeli Hospital, is one of the best-known health unities in Brazil and Latin America. Finally, for this panel, I would like to present our silver sponsor, Urbano Vitalino Lawyers from Recife, Brazil. Now, directly from India, I would like to present Mrs. Paheli Bhattacharya with the replay of her paper, Incorporating Domain Knowledge for Extractive Summarization of Legal Case Documents. This paper was presented this morning and now will be replayed for you, and Mrs. Paheli will be available here for questions and answers that she will give to previously registered questions in our platform OpenFi and also on YouTube channels. So now, please, the floor to Mrs. Paheli again for her replay.
Charya from the Department of Computer Science and Engineering at IIT Kharagpur, India. I will be presenting our work, Incorporating Domain Knowledge for Extractive Summarization of Legal Case Documents. So case documents are inherently very lengthy, free-flowing, unstructured, and dense legal text. Reading and understanding these documents is difficult even for legal experts. Therefore, it is necessary to summarize these case documents. Existing legal IR systems employ attorneys or paralegals to manually write summaries. This incurs a high subscription cost of these systems. This calls for the need of developing automatic summarization systems with the overall objective to improve the legal understanding with lesser dependence upon experts. Now, document summarization is not a new problem. There are methods for news document summarization, scientific article summarization, and so on. Let us see what is different in legal case documents. So on the left, there is a news document. So as we see that it is a very short document, and the first paragraph usually summarizes these news documents. Next, there is a snippet of a scientific document, particularly a research article. So these documents are lengthy, but they are segmented into sections and subsections with paragraph headings. On the right, you can see a case document from the Supreme Court of India. These documents are lengthy, and it is just a free-flowing text with no section headings. There is something called rhetorical segments in a legal case document, but these segments are often not explicitly mentioned. Let us understand what these rhetorical segments are. So rhetorical segments or labels in a case document are the semantic functions which sentences in a case document plays. So these are usually one of the following labels. Facts, that is the sentences that denote the chronology of events that led to filing the case. There are sentences that denote the legal issues being discussed, so we call them as issue. There are also sentences that denote the ruling or judgments given at the lower courts, so we call them ruling by lower court. Similarly, there are arguments by the contending parties, which we call as argument. Sentences that have citations to established laws by the current case, which we call as the label statute. There are also citations to prior cases, and we call these sentences as precedent. There are sentences that describe the rationale or the reasoning of the court for the final ruling, and we call them as ratio of the decision. And finally, the sentences that give the final judgment or the conclusion of the court. So on the right, this is an illustrative example of how a case document, when the sentences are labeled with each of these rhetorical labels, looks like. So the first approximately four sentences have been labeled as facts. Then some sentences have been labeled as issue. Then one sentence has been labeled as ruling by lower court, and so on. So legal experts have some guidelines on how to summarize a case document. Some of these guidelines from USA and UK are given in the links below. We also discussed with law experts from India, and all of them basically devise the following set of guidelines. So the first one is that each rhetorical segment should be summarized well and have representation in the final summary. This is because often law practitioners or academicians or others wish to read only the summary of particular segments. Example, summary of only the facts or summary of only the ratio. So this following this guideline is important. Second is that each of these segments should also, the important parts of each segment should be present in the summary. For example, from the statute segment, sentences that cite the relevant acts or laws should be present. Now let us see what are the existing methods for case document summarization. So in this work, we are considering extractive text summarization algorithms. So they can be broadly classified into two main families, domain independent and legal domain specific. And under each of these families, there are supervised and unsupervised methods. So under domain independent supervised methods, we have the state-of-the-art deep learning models like Summerunner, BERTSUM, and so on. So as these are deep learning models, they require huge amounts of training data, which is expensive to obtain in the legal domain. Also, these methods were developed and evaluated on news documents, which are short. But when we apply them to summarize lengthy case documents, these algorithms become very resource intensive. Coming to unsupervised domain independent methods, so they can actually summarize any document. So they do not incorporate any legal domain specific knowledge. Now coming to the second family of methods, legal domain specific. The first one is the GIST method, which is supervised. As it is a supervised method, it requires large amounts of training data. Also, although it is legal domain specific, but there were no domain specific attributes such as rhetorical labels considered in this algorithm. Finally, there are many legal domain specific unsupervised methods. So case summarizer is one, but this algorithm does not assume the presence of any rhetorical role. So they rank sentences based on some importance score, but this score is based on a heuristic where there is no parameter from the rhetorical role perspective. The other three methods, LETSUM, KMM, and MMR, uses a rhetorical information, but just to display the summary in a templated format. It does not use rhetorical information in estimating the importance of sentences for generating the summary. For instance, LETSUM uses TF-IDF to measure the importance of the sentences. In short, there are two main drawbacks of the prior works. The first one is that the existing algorithms do not incorporate legal domain specific knowledge systematically. While the supervised methods are expected to learn these rules automatically, there are two disadvantages. First is that there is a scarcity of expert written summaries in large amounts to be used as training data. Secondly, summary requirement may vary for different stakeholders. For example, a journalist who is briefing a case wants a different type of a summary. Maybe he or she wants the ratio to be summarized well, whereas a law practitioner may want the facts and arguments to be summarized well. So it is not practical to gather huge amounts of training data to cater to each type of the stakeholders. So in this work, we propose DELSUM, which is an unsupervised domain adaptive extractive legal summarization algorithm. DELSUM works in an optimization framework to incorporate legal domain knowledge into an objective function with constraints, and this objective function is maximized using integer linear programming. So DELSUM takes as input a document where each sentence is labeled with a rhetorical role and the desired length of the summary in number of words. Let us call that L. So given these two inputs, DelSum produces a summary of at most L words. So the optimization framework of DelSum has two main components. The first is the informativeness of a sentence. It measures the amount of important information contained in a sentence. We assume that domain experts will define how to estimate the informativeness of a sentence. The second one is the content words, that is the words that signify domain-specific vocabulary. With each content word is a score which shows how important that content word is. Again, we assume that domain experts will define what the content words are and how the scores are defined. DelSum produces a summary that maximizes the following objective function. That is, it tries to maximize the inclusion of informative sentences and the number of important content words, subject to constraints that the summary length should not exceed L words. And there are other constraints, so please refer to our paper for more details on this. Now let us see how the legal expert guidelines can be incorporated into DelSum. In this work, we considered summarizing Indian Supreme Court case documents, and our experts are the senior law students and a professor from the Rajiv Gandhi School of Intellectual Property Law, which is a reputed law school in India. So the first guideline they gave us is that in general, the summary should contain representations from all segments of a case document, and the relative importance of segments in the summary should be as follows. So first and foremost are the final judgment and the issue. Next comes the facts. Then the statutes, precedents, and ratio are of approximately same weightage. And then comes arguments, and the other label, ruling by lower court, is not so important to be included in the summary and may as well be discarded. So we formalize this in DelSum as follows. So we have a variable called weight K, which defines the weights of each of these segments, and we assign the highest weight to the segment's final judgment and issue. And for the other segments, the weights decrease exponentially or linearly. We may as well assign discrete scores to or discrete weights to each of these segments. The second guideline is that the segment's final judgment and issue are exceptionally important in the summary. The segments are usually very short, and so they should be included completely in the summary. And to ensure a balanced representation, a minimum of 2 sentences from the other segments should be included. We formalize this guideline in DelSum as follows. We have a variable NOS, or number of sentences for a segment K, defined as follows, that if the segment is final judgment or issue, then all of the sentences should be taken. Otherwise, a minimum of 2 sentences should be taken. The third guideline is that the important sentences should be decided based on which segment that sentence belongs to, and also other factors. If the sentence is from fact, then we will take the weight of the segment fact and also the inverse of the position of the sentence. If the sentences are from the segment statute, then we will see if the sentence contains citations to an act. So for that, we keep an indicator variable AI for statute, and this AI is 1 if there is a citation to an act, otherwise 0. Similarly, for precedents, we see if the sentences contain citations to prior cases. And for the segment ratio, the guideline is that the sentences appearing at the end of the document and those that discuss relevant statutes and precedents are important. So to formalize this, we assign the weight of the segment ratio, that is weight K, the position of the sentence, and whether there is a mention of statute or a precedent. The final guideline is that the summary must contain sentences that give important details of the case, including acts and sections of acts that were referred, names of people and places, and also sentences containing specific legal keywords are important. So we formalize this by having 3 types of content words. The first one is the acts or sections of acts, to which we assign a score of 5. The second type of content words are the keywords from a legal dictionary, to which we assign a score of 3. And then we have the noun phrases, to which we assign a score of 1. Now, let us see the dataset and experimental details of this paper. So in this work, we considered 50 Indian Supreme Court case documents, where each sentence of a document was labeled with one of the 8 rhetorical segments. So this dataset is available from our prior work. Each of these 50 documents had gold standard summaries written by 2 senior law students from the Rajiv Gandhi School of Law. They wrote segment-wise summaries and they combined ratio and precedent into one segment analysis. The summary lengths were approximately 30% of the original document, and we had 2 sets of summaries. The metrics, the evaluation metrics we considered are the rule scores between the gold standard summaries and the algorithmic summaries. We considered several baselines. So from the 4 families, which I described in one of my earlier slides. So from the unsupervised family, we have domain independent as well as legal domain specific methods. And from supervised also, we have domain independent and domain specific methods. So the supervised methods were trained on 7,100 document summary pairs. So details of this training mechanism can be found in our paper. So now let's see the results of the approaches and also some analysis. So this table shows the Rouge 2 and Rouge L recall and F scores. So out of all the domain specific methods, both supervised and unsupervised, we see that DELSUM performs the best for all the measures. While comparing with supervised domain independent methods, we see that DELSUM outperforms both SummerRunner and BERTSUM. The difference with SummerRunner in Rouge 2 is not statistically significant. Note that DELSUM is unsupervised, whereas SummerRunner and BERTSUM were trained on 7,100 documents. Next, we do a segment-wise performance evaluation. So in this table are the segment-wise Rouge L F scores of all the methods. So values in red underlined are the ones which are less than 0.3, and the best value for each segment is in green bold. So as one can observe that DELSUM performs best in 3 out of the 6 segments, and overall it achieves a balanced representation of all the segments in the summary. Especially DELSUM performs better for final judgment and issue, which are the most important segments in the summary. These are also the shortest segments. Other algorithms with no domain knowledge completely misses these segments. So we have more analysis and intuitions in the paper. So till now, we have been using expert assigned rhetorical role labels for summarization. But in a practical scenario, it is not possible that sentences in the input case documents will be labeled by the experts. So in this experiment, we use a state-of-the-art model to first rhetorically label the documents and then feed them to DELSUM. So the results show that the performance does not drop much, even when the rhetorical labels are around 80% accurate. Let us now give a brief note on the generalizability of DELSUM. So DELSUM is generalizable to documents from different jurisdictions as well as different stakeholders like law practitioners, students, etc. So this is because DELSUM is quite customizable, and this is through the different parameters like the segments and weights of the segments can be defined by whoever is using this algorithm. Also, the minimum number of sentences from each segment can be given as input. Finally, the content words and what will be the weight of these content words can be decided by the different stakeholders. DELSUM can be modified to include various guidelines. For example, if a stakeholder or jurisdiction wants the summary to have facts and final judgment, then WK and NOSK should be kept higher for K is equal to facts and final judgment. Similarly, if there is a use case that the statute sentences should be more than the sentences with noun phrases, then the score of the statute words can be kept higher than the score of the noun phrases. So to conclude, in this work, we propose DELSUM that can efficiently encode domain knowledge for extractive summarization of legal case documents. We show that it is necessary because important segments like final judgment and issue gets missed in otherwise unguided algorithms. DELSUM achieves a balanced representation and it can also handle redundancy efficiently. It is also generalizable to different jurisdictions and stakeholders. So as a future work, we plan to explore how these otherwise hand-tuned parameters of DELSUM can be automatically derived, how the weights can be automatically derived. So our implementation of DELSUM is publicly available. So I would like to conclude by acknowledging the law experts from the Rajiv Gandhi School of Intellectual Property Law, India, TCS for their fellowship, the Mirror EU project, and Complex Networks Research Group, IIT Kharagpur. Thank you, and I can take questions now.
Mrs. Paheli Bhattacharya, thank you again for your presentation. Now, our team has selected 2 questions from the audience. The first one from Brazil is a comment made by Mrs. Kaliani Pimentel. She says that you have a very interesting study and that in Brazil, this could complement case law headnotes, which are made without AI resources and generally by law clerks. Please, Ms. Paheli, the floor is yours.
Yeah. To answer this question, what you call as head notes, we call it as summary, case summary. So they basically mean the same. So yes, our method can be used along with legal experts. So in a way that the guidelines on how a head note should be produced. So these guidelines will actually come from the legal experts or the law clerks. So, yeah.
Okay, thank you, Ms. Paheli. I guess we are having some connection troubles, but can you listen to me?
Yeah, I can hear you. Is my voice breaking? Or?
Okay, no, it's just okay. The problem is the camera. I believe we cannot see you right now because of connection,
okay.
but we can listen to you perfectly. Okay, now we can see again. Okay, perfect. May I pose you the second question? Is that okay for you?
Yeah.
Okay. So 1 second. We have a second question from Mr. Carlos Braga from Brazil as well. So he says, since the automatic summarization model was developed based on the structure of Indian court decisions, what are the main challenges in adapting this model for application in other countries?
Okay, so to adapt it to other jurisdictions, we have to customize the different parameters of DELSUM. So the main parameters are like what are the rhetorical segments. So for Indian court decisions, like we have devised 8 rhetorical labels. So for some other jurisdictions, some other set of labels can be devised, and according to that, one can incorporate that into DELSUM. Apart from that, we also have to say that how much representation is required from each of the rhetorical segments into the summary. So for instance, in Indian court decisions, we understand from our legal experts that the final judgment and issue are very important, whereas the arguments and ruling by the lower court are not very much important in the summary. So we assign the weights of the segments accordingly. So this also has to be adjusted according to the jurisdiction. And finally, how to define important sentence, that is deciding like which sentences should go into the summary. So this importance score should also be defined. So here we have done it through content words. So one can devise different content words for different jurisdictions according to like what is required. Yeah.
Okay, perfect. Thank you, Ms. Paheli. We have a third question from the audience. I don't know if you are able to answer or not. Just in case,
Yeah.
I believe, yeah,
Okay.
I believe we're running out of time actually. So I'll just pass the floor again to you for a final moment, one last minute, then you can have 1 minute more, okay?
Okay, so yeah, I can see one question that how to identify the rules to offer an effective summarization. So yeah, so these rules can either be we can either get them from the law experts or the different stakeholders who wants to have the summarization, or in the absence of the some expert, you may see some summaries by yourself, and you can have an idea that yes, from this jurisdiction this kind of summary is required, and you can adjust the parameters of the sum accordingly. The other question I see is that why not output just a structured representation of the case. So so this problem is actually of summarization. So for example, given n sentences of a case document, we have to select some L sentences out of n. So this is why it becomes an objective function with constraints, where we have to maximize selecting the L sentences which are actually of very importance. So that is the basic task of summarization. Okay, so yeah, so thank you for giving me this opportunity to present at IKL. It was very good to interact with the audience. So I would request all of you to please go through our paper, and we also have our code available on GitHub. So you can get back to us, to all the authors, if you have more questions. Thank you.
Thank you very much, Ms. Paheli, for your brilliant presentation. And now I have a pleasure to call here to the stage Mr. Guilherme Moraes Rosa, also from Brazil, our Brazilian colleague, which will have a 10-minute presentation of a live paper called To Tune or Not to Tune, to tune or not to tune, zero-shot models for legal case entailment. So, Mr. Guilherme, can you hear me?
Yes, I'm hearing you. I'm going to share my screen.
Okay, perfect. I'm not seeing your video, but anyways, I believe it might be my connection.
Now you can see me?
Oh, yeah, now I can see your video. Perfect. And now, please, you can share your screen.
Okay. Is everything okay? Can you see my screen?
Yes, we can. Perfect.
Okay. So first, hi, good afternoon for everybody. My name is Guilherme Moraes, and for me, it's an honor to participate in this event. And in my presentation, I'm going to talk about domain adaptation and zero-shot models. Specifically, I'm going to talk about domain adaptation to the legal domain, and also about a proposed zero-shot approach to the task of legal case entailment. Legal case entailment is the second task of the colleague competition in which we got the first place. But before starting my presentation, I'd like to introduce the other authors who participated in this work, which are Juan Chaves, Roberto Lotufo, and Rodrigo Nogueira. So, well, I'm going to start my presentation by talking about zero-shot learning and also about some related works that have applied zero-shot models to domain-specific tasks. Then I will briefly present some topics to provide a background on our work. Next, I'm also going to explain the zero-shot model that we use and how it was adapted for the colleague task. And to finish, I will present the results and the main conclusions. So let's start. Well, Recent evidence shows that models trained on large and diverse data sets can achieve good performance in many out-of-domain tasks, and we can consider this situation as a zero-shot scenario, since the models were never trained on data coming from the target domain. In addition, we also know that zero-shot and few-shot models are becoming more and more competitive with fine-tuned models. So to test this new evidence and also to investigate the zero-shot ability in the legal domain, we participate in the legal case entailment task of colleague competition, and we were able to achieve great results using models with no adaptation to the legal domain. But I have to say that we were not the first to try this kind of approach. For example, using the same model used in this paper, Nogueira et al. Demonstrated a zero-shot approach that performed better than trained models on the test set of track robust. Another good example is Zhang et al. He used a zero-shot model to create a search engine to information about COVID-19, and his model was able to get a good performance on the track COVID dataset without being trained with any data about COVID-19. And there is also the work of Pradeep et al. He applied a zero-shot approach to achieve the best or second best performance in specialized tasks of the text retrieval conference, for example, the track precision medicine and track COVID tasks. Well, a common feature of all these works that I've been talking is that the models were only trained on a general domain data set, and they didn't need any domain data to achieve the good results. But despite all these works in different domains that we have in literature, as far as we know, there is no strong evidence that zero-shot models have this similar behavior on legal domain tasks. So, until now. So the main contribution of this work is that we show for the first time for the task of legal case entailment a zero-shot model that performs better than models adapted to the legal domain. But before going into detail about the proposed approach to this task, I'm going to explain some important topics to provide a background about the presentation. Well, the first topic I'd like to talk is zero-shot domain adaptation. Zero-shot domain adaptation is when a model is able to solve a task in a target domain without receiving any trained examples in that same specific domain. In our case, the model has never seen text from legal domain, and it was only trained on text coming from general domain. Now, speaking about the COLI competition, COLI is an annual competition promoted by the University of Alberta, and the goal is to improve automated systems on legal tasks. And among the 5 tasks of this year competition, we participate in 2 of them, the legal case entailment task and the legal case retrieval task. And in this presentation, I will talk specifically about the approach we propose to the task of legal case entailment. The goal of this task is to identify a set of paragraphs from existing legal cases that are relevant to a new case. And as you can see in the table, our submissions got the 3 top scores, achieving more than 6 points above the second best team. Also, in our experiments, we use 2 models that are the Beta and Mono-T5. The Beta is an improvement over some previous transformer architectures like BERT and RoBeta, and this model is the state-of-the-art in many NLP tasks. The second model we use in this work is Mono-T5. Mono-T5 is a model adapted to the task of text rank, and it is based on the T5 architecture. Mono-T5 is also state-of-the-art in some information retrieval tasks, and it is the model responsible for the zero-shot approach we use in this work. And on the next slide, I'm going to explain how Mono-T5 was trained on a general domain dataset and apply it to the COLI competition task. Well, as I said, Mono-T5 is an adaptation of the T5 model for the task of text rank. The model was proposed by Nogueira et al. In the year of 2020, and the model was trained on MS Marco dataset. That it is a big dataset with 500,000 of text passage, and it was built for the tasks of text rank and question answering. Well, during the fine-tune step, Monody 5 is trained to generate the tokens true or false, depending on the relevance between a document and a query. And to train this model, we use this input template that I show in this image on the left in green, where the letter Q represents the query, and C is the candidate document that may or may not be relevant for a specific query. On inference, the model estimates a score to quantify the relevance of a document to a query, and this score is given by the probability assigned by the model to the token true. Well, in this slide, I present the results of the experiments. All models were trained and evaluated using the Colli competition dataset, except for Monody 5 zero shot that was trained only on MS Marco. And the approach we use for this task is considered zero shot because the model was trained and evaluated on datasets coming from different domains. In this case, we trained it in a general domain text using the MS Marco dataset. So our zero-shot model has never seen text from the legal domain during training, only during inference. And as can be seen in this table that I show, the results shows the efficiency of the zero-shot approach, because despite not having been trained in any data coming from the legal domain data, Monody 5 zero-shot achieves a better performance than the beta and Monody 5 models that were trained on the Colli dataset. In addition, our zero-shot model achieves the best result of a single model in this task, and also performed very close to the beta T5. The beta T5 is an ensemble between the beta and Monody 5 models, a combination of both models, both trained on Colli dataset and considered the best submission for this task in the competition. Well, it is important to note that despite the beta 5 performance being the best among all submissions in this competition, this ensemble demands training time, computational resource, and also data augmentation to perform well in the legal case entailment task. While Monody 5 zero-shot doesn't need any adaptation. The model is already available online, and it is ready to be used. Now, coming to the conclusion of the presentation, I'd like to say that in this work, we show for the first time for the legal case entailment task that models without fine-tuning to the target task can perform better than models trained to the task itself. The results show in the legal domain a counterintuitive finding similar to other domains that, given limited label data, models with no adaptation to the target task may be more robust to change in data distribution. They also may have a strong generalization ability, and they also tend to perform better on held out data sets than models trained on the target domain. We also know that domain-specific models and adjustments made during the fine-tune process are promising directions for future research, but we believe that zero-shot approaches are very important because they allow the development of high-performance systems for tasks or for domains that have low availability of data. And a good example of the scenario of low availability is the legal domain. And in addition, the zero-shot models can also be used as strong baselines in our experiments. Now, to conclude, it is important to say that this research may have implications for new experiments beyond the scope of the legal case entailment task. And it is also possible that other legal tasks with limited label data, for example, the legal question answering task, could also benefit from our zero-shot approach. And now, before finishing my presentation, I'd like to introduce you to the members of the NeuroMind team. And to conclude, I'd like to thank you all for watching.
Thank you very much, Mr. Guilherme, for your brilliant presentation. It is very nice for us Brazilians to have you here. And now I have one question from the audience. So Mr. Marcelo Lopez from the organization team, he's asking, what are the main difficulties in using fine-tuned models in the legal domain?
I think that the main difficulty is the low availability of label data to fine-tune the models. That's why we are proposing this approach using a zero-shot model.
Perfect. Thank you very much, Mr. Guilherme. Now you have one last minute your last talk, please.
I simply would like to thank you for the opportunity, and it's a pleasure to participate in this event.
Thank you very much, Mr. Guilherme. It was a pleasure for us. Now, directly from Japan, I'd like to call here to the main stage Mr. Ken Sato, which will have 5 minutes for a demo live presentation of interactive system of arranging issues based on proleg and civil litigation. So please, Mr. Ken Sato, the floor is yours.
Can you see the slide?
Yes, we can see your screen perfectly.
I'd like to show you interactive system for arranging issues based on proleg in civil litigation. This is joint work with Kazuo Takashi and Tatsuki Kawasaki. Firstly, I would like to give a background and then I give a demonstration. So in Japan, we have the procedure of arranging issues in civil litigation where we clarify which facts are in dispute and what kind of evidence action should be made. And in the beginning of 2020, the Japanese court decided to use online meeting software for arranging issues, but it is very superficial IT technology. So I would like to make it more intelligent. And we have been developed proleg-based legal reasoning support system proleg since 2009 to simulate reasoning by judges in litigation. In this presentation, we extend proleg into an interactive system for arranging issues. So it is necessary to extract the legal facts from various real-life facts to form an appropriate argument in the court. However, it is not clear which of real facts are needed, and proleg can choose required facts automatically by reasoning about the rules, which encodes a civil code. So the demonstration is as follows. The plaintiff Alice requested the defendant Bob for the payment of goods according to the purchase contract with Bob. Bob claims that Alice threatened Bob to buy the goods for a counter-argument, but Alice didn't admit the threatening action. So I'll show you now the demonstration. And first, the plaintiff chooses what he would like to do. And here, I want to request money. And then the user chooses which reason why he could request money. And in this case, the purchase contract. Then the proleg compute the necessary fact. And user plaintiff must put relevant fact here. And this part is changed from Q to O, which is that the plaintiff states it, allege it. And then we can simulate judgment here, and this part becomes O, which means that the plaintiff wins. And then this block diagram is sent to defendant, and then he asked proleg to compute counter-argument here. Then we can see that there are two possible counter-arguments, and in this case, defendant choose this counter-argument and put necessary facts here. So these facts are also computed by ProReg automatically. And we claim this, then apply it. And then we can simulate judgment again with this added fact. And then this becomes crossover X, which means that the defendant wins or and the plaintiff lose. So then it is sent to plaintiff again, and then the ProReg computes counter argument here. But unfortunately, there is no counter argument here. So only he can do is to deny the fact or making the facts issues, so that it becomes U, and this part is also U. So he denies duress action here. And then we can simulate the judgment again. In this case, this part becomes U, undefined, unless these issues are solved. So we can arrange the issues using this interactive system. So I conclude my talk by using extension ProReg. Attorneys can prevent missing claims by using this system for checking, and the layperson could make correct legal claims. As a future work, we would like to develop the system and pursue automatic information extraction from natural language sentences. Thank you very much.
Thank you very much, Mr. Ken Sato, for your brilliant presentation. And now, directly from Canada, I would like to call to the main stage Mr. Ernest Thiessen and Mr. Graham Ross to a live demonstration of a working collaborative e-negotiation system. Please, Dr. Ernest, the floor is yours.
Okay, hi, it's great to be here, and following me is going to be Graham Ross. I'm from Smart Settle, and Graham Ross is working with us as well, also representing ODR training. So I'm going to share my screen now. I've got a short presentation here. Let me see, you should be able to see now the first screen. It says optimizing e-negotiation outcomes with collaboration algorithms. So, you know, we were asked to do a demo of Smart Settle Infinity in 5 minutes. There's no way we could do that. So this 5-minute presentation is just about the algorithms, and but we did produce a video for you, and it's called Infinity Made Simple on YouTube. So when we're done here, you just search for Infinity Made Simple. It's a negotiation between teacher and farmer, and you know, some issues about negotiating pumpkins there. And so in the original distributive negotiation, they were lucky to achieve 50%, but they could do better with those algorithms. So let's see how. If we rearrange the scale, we can depict this problem and change it into an integrative negotiation in multi-dimensional satisfaction space. Now, teacher wants to be at the top left, and the farmer wants to be at the bottom right. When the previous
I'm not seeing the screen. I don't know if it's just me, but
oh,
I'm not.
Oh, you can't see the screen.
Yeah.
Oh no.
Does anybody else can see it? Ah, it's coming on now. Now we can see it.
Now we can see it. Yes. No problem, Dr. Ernest. You can start again if you need. Okay.
Oh, okay. Well, let me see. Let's just try that again.
Okay, we're at the beginning now. Yeah.
Can you see it now?
Yep. We can see with your notes.
Yes,
If you want to play it.
Yes.
Okay. Let's see.
If you play it.
Again.
Okay.
How about now?
Yep.
Is that better?
Perfect. Perfect.
All right. So it's about optimizing outcomes with collaboration algorithms. And you heard what I said before, that this is about the background theory. So we made a video for you called Infinity Made Simple on YouTube. It's about teacher versus the farmer, and negotiating about pumpkins. There's lots of issues, and they would be lucky to achieve 50%, but we can do better with those algorithms. So, okay, so we're going to rearrange those scales so we can look at the problem in multidimensional satisfaction space. Now, teacher wants to be at the top left, and farmer wants to be at the bottom right. So in the previous scenario is plotted, we can see that it's actually possible to do better. You know, they're short of the efficiency frontier here. And a famous person called John Nash, Nobel laureate John Nash, worked on this quite some time ago, and he said, traditional negotiations end up at the Nash equilibrium. However, with maximized utility product and a dose of collaboration, negotiators can get to an optimal solution. Unaware of Nash's solution, my major advisor at Cornell University gave me a challenge, and I invented maximize the minimum gain. My experiments predicted 16% gains for each party. And the late Harvard professor, Emeritus Howard Rafa, considered then to be a leading expert, published a preference for this algorithm. But unfortunately, further research showed that this method was incomplete. Negotiators are very attached to the baseline and too exhausted to go further. Some years later, visual blind bidding was born. Visual blind bidding virtually eliminates the tedious negotiation dance that characterizes traditional negotiations. A comprehensive process first creates a single negotiating framework. This is like the final agreement, except for blanks representing the unresolved issues. Sophisticated modeling enables parties to represent their preferences so that they can easily determine how much each package is worth, and also define minimum satisfaction. Any area above is called the zone of possible agreement. The neutral site helps parties exchange proposals, and neither of the initial proposals here is acceptable to the other party. But Smart Settle, knowing how each party becomes satisfied, can generate intelligent suggestions. If the parties place secret bids on satisfactory packages, Smart Settle will check if there's an overlap. If there's a small gap, then the automatic deal closer can close it instantly. Fairness enhancing normalization encourages parties to focus on what they want by making sure that no one is able to game the system, while maximize the minimum gain harvests and fairly distributes any remaining hidden value. In the rare case of no agreement in final session, the expert neutral deal closer can guarantee a collaborative outcome. Throughout the process, another algorithm called reward early efforts works to discourage holding back. Increased settlement rates save time and money in all types of negotiations and promote access to justice. 3 decades of R&D have resulted in the 8 algorithms listed here. You can learn more on the Smart Settle website. Search for Infinity Made Simple on YouTube to view the simulation that I talked about. And thank you very much for your attention. It's great to be here, and over to Graham Ross.
Thank you, Eddie. A pleasure to be here, to be invited to present here. Let me give you a working UK lawyer mediator, as I am, perspective of the Smart Settle products, which I have used particularly Infinity. First of all, just, I suppose, introduce myself. I'm, as I said, a UK lawyer mediator. I'm a board member of the International Council for Online Dispute Resolution. If you've never heard of it, icodr.org. If you're interested in online dispute resolution, you really ought to be a member. I'm also a board member of Smart Settlement Resolutions Incorporated, a member of the Working Party of the UK's Civil Justice Council ODR Working Party, and I've been running for some 13 years the leading training course on ODR. But let me give you this perspective. I really love Infinity. And let me give you 5 reasons. I love it because no settlement is ever reached on the system unless it's been notified as acceptable to both parties. So this is not the machine telling people how to resolve. It's helping people to resolve it. I love how it requires skilled mediators to accurately inform the machine of the preferences of each party. So there's no jobs, no mediator is going to be out of work because of this. This is an example, a very good example of that other AI, augmented, not artificial intelligence. It's augmenting the skill of the mediator. Thirdly, I love how the parties can submit proposals to the system anonymously, and the other party doesn't know when it looks as a proposed package to settle if it came from the opponent, from the mediator, or from the machine, because the machine learns so much from what is fed into it that it can identify what is more likely to be acceptable to both parties. In that way, proposals that are made are looked at in a truly objective fashion without any emotion. And you know, when there's a lot of anger and in a dispute between parties, often people will not accept an acceptable offer simply because it came from that other person with whom he is in disagreement. Fourthly, I love how you can use it even outside of mediation, just for a party to model a negotiation strategy before entering into mediation. And fifthly, and finally, I love how it focused the parties' minds from the outset on the final part of it, the resolution, rather than spending all this time arguing over the previous facts that led people into the dispute in the first place. It's extremely positive. Just give you one, finally, a real world example of how all this fits in. Imagine an unfair dismissal. An employer sacks somebody and the employee feels it was done infernally and he has rights to claim compensation. Now, supposing that when this employee took up the employment, the contract said that when he left the employment of the company, he mustn't work, he could not work in the same industry for 2 years. Now, using Infinity, the mediator would want to find out from the employer what their interest in maintaining this bar out really was. Now, imagine the employer said, oh, we're not really bothered about this bar out. This man can't cause us any damage. He wasn't very high up in the in the food chain. Whereas for the employer's point of view, he might tell the mediator using Infinity, trying to assess his preference, that it was really be really important if he could avoid having this bar out. And so in this situation,
Graham, they want us to wind it up.
Sorry?
They want us to wind it up now.
Yeah, so I'm right on the end. So Infinity would say, maybe the employee will take less compensation if he is released from the bar out. And that's how, if that was put openly, it would never be accepted by employee. He would never want it known that they weren't that important. There you are, falling in love hopelessly with Infinity, and I recommend it. Thank you very much.
Thank you very much, Dr. Graham, Dr. Ernest. It was our pleasure to have you here. And this is the end of our panel, our 4th panel of the day. I'd like to thank everyone, our audience. And finally, I'll very quickly share my screen and show you where GatherTown is on our OpenFi platform. We are all going to meet during this 1.5 hour break there in GatherTown. So I'll just share my screen here and show you how to log in on GatherTown. Can you see my screen correctly, like GatherTown with the homepage here? Can you see, Dr. Ernest? Okay. So here in GatherTown, go to the left part of the panel and click here in the star, on the star, where is GatherTown. So here you can join us, okay, inside the platform, and you click there and you have Gather. You only have to prepare yourself here, write your name on it, and launch with your browser. And we will be there for networking space. So you are all invited to join us there. Our sponsors, they have also a place there. I guess you can see my screen, right? I'm using here GatherTown. So I just joined the room and I'll be in Jus Brasil room here with, for example, Mr. Juliano is here with me. And there is another room, which is Albert Einstein room, that you can also have this option to join it. Okay, so you're all invited to join us at GatherTown.
So which room should we go to?
Sorry?
Which room are we supposed to go to now?
Now, yeah, we just finished our transmission and we are finishing the panel. And then if you want to join us for networking space on OpenFi, you have to log in there and go to GatherTown. Okay, so thank you very much for your attention.
This is your book, the patriotism. You see there in passages
1, 2, 3. Greetings, everyone. Welcome to the 18th International Conference on Artificial Intelligence and Law. My name is Jackson Souza, and this is the 5th panel of the second day of the event. Before we can start, I will present you our sponsors, our platinum sponsors. Jus Brasil. Jus Brasil is currently the #1 law and government website worldwide with 28 million unique users each month that makes high-value legal information super easy and quick to access, thus saving its users time and providing sustenance for their case strategies and insights. Their purpose is to improve justice, social trust, and transparency by democratizing access to high-quality and relevant information. They inspire to be the single source of truth for legal information. And Albert Einstein Israeli Hospital. Albert Einstein Israeli Hospital, one of the best known health units in Brazil and Latin America for the quality of care and for the equipment and medical specialties available to treat many types of pathologies. The hospital is referenced in treatments with state-of-the-art technology and humanized care, expanding its borders with social responsibility actions, teaching and research activities. With over 50 years of existence, the Albert Einstein Israeli Hospital still maintains a premise to innovate and grow, always with excellence. So, to start, we have a full paper streaming with the title Precedential Constraints, the Role of Issues, that will be transmitted and was given by Trevor Bench-Capon. And the presentation has 20 minutes. You can start, please.
This is joined by the Casey Atkinson, who you see there in happy as rose when we can actually meet at the time. That's in San Diego. My paper has 3 topics: the relation between factors, dimensions, and facts. And I will argue that presidential constraint is best expressed in terms of factors. And factors are assigned to applicable dimensions on the basis of facts. Precedence constraint issues is the second point. And it's issues that constrain cases. So when thinking about precedent, you also think about issues, not cases as a whole. Factors in cases should be structured into issues to avoid irrelevant disputes. And the third topic is presidential constraint only needs factors. We don't need to express presidential constraint in terms of dimensions. Where magnitudes are important, and they are important, we first apply factors on the basis of dimensional facts, and then we apply constraints. So, the history of understanding presidential constraint is a lengthy one. At the very first edition, Edwina Rusland and Heliassi presented a paper which understood them in terms of dimensions. In 1995 onwards, Cato, with Vincent Leaven and Heliassi, introduced the notion of factors. Then Henry Pachen and Giovanni Sarto showed us how we could write precedents as rules. My contribution in 1999 was to consider the antecedents organized in partial order. And then still ongoing is where informal characterization of presidential constraint. began by John Hawley, continued by Adam Bajoni, and summarized by Henry Patten in a paper this year. So, how do we move from dimensions to factors? The dimensions tell us what needs to be considered in a case. If the dimensions are applicable, it may, not must, it may provide a reason to decide for one of the parties. These reasons are referred to as factors. Factors refer to the significance of the dimension in the particular case. Sometimes the dimension is either inapplicable or favours one side, in which case it will correspond to one factor. Sometimes it's inapplicable or neutral or favours a side, and the dimension may have more than one factor favouring the side to differentiate different degrees of favour. And sometimes the dimension may be neutral, or it may favour either side. And this dimension has distinct factors to the different sides. Factors should never be related. An action factor may be inapplicable, it may be neutral, it may be a factor for the other side, or a different, stronger or weaker factor for the same side. It's confusing to bundle these very different things under relation. So, moving from the dimension to a factor, let's consider the disclosure dimension. If we have no disclosures at all, the dimension is inapplicable. An insignificant number will lead to no factor. A significant number will lead to a factor, S same in paper. And in the public domain, we have the very strong co-dependent factor, S27 in paper. So as we move along the dimension, it's first inapplicable, then neutral, then dependent, then strongly dependent. It never favours the plaintiff. Another dimension, security measures, can favour both the plaintiff and the defendant. So we have two distinct factors, S19 and S6. S19 applies if the measures are inadequate. S6 applies if they're adequate. So the dimension is always applicable, but there's a neutral area in which no factor applies. Precedents determine where these switching points occur. S19 is not related to the aspect. It provides a reason for the defendant, but the neutral range does not. So now we consider how can we write precedents as a set of rules. A case can be seen as P union V implies O, where P is the plaintiff factors, V the defendant factors, and O the outcome. So P is the strongest reason assigned to the plaintiff. V is the strongest reason assigned to the defendant. And O will be either plaintiff or defendant, and will show which of these reasons is preferred. So we get three rules: a plaintiff rule, a defendant rule, and a rule expressing a preference between these, depending on the outcome. We can represent this graphically by representing the possible antecedents as two parts rules. The one on the left for the plaintiff, the one on the right for the defendant. Now a precedent will place an arc between these rules. So if we have A, B, C, D, E decided to the 20, that shows that A, B, C is preferred to D, E. If B, C, D, E is decided to dependent, that shows that D is preferred to B, C. Now if we have a U case, it's constrained if it's a reproducible cipher. If we have a case A, B, C, E, then we can put the arrow as either end and there's no cipher. So we can do what we like with cipher. However, if we have C, D, E, that's constrained to the descendant. If we were to decide to the plaintiff and prefer C to D, E, we need to use the cipher. We can't have a cipher, and so we have to decide to the defendant. This basic idea has been formalized starting with John 40, going on to Latin with Henry, and finishing this year with Henry Buck. And there's a list of the papers. The formalization is rigorous, and it shows that all the desirable properties we would want to hold do in fact hold. And it comes in two forms, the results model and the reason model. The results model uses all available facts. No interpretation is needed, both sides offer their strongest reason. But, unfortunately, it does not in fact constrain many cases. It only supports a certiorari reason. The use case, if it is to be constrained, must be subsumed under the pressure. But we want more than this. We want to be able to argue for cases which, while not subsumed, are constrained by the pressure. Suppose we have a case with security measures, invasive techniques, and disclosures are outside, and a precedent which has similar factors, but also the unique product. We want to say that the use of invasive techniques, such as wiretapping, is sufficient. The actual uniqueness of the product as little. But on the results model, the precedent does not bind because FAC is not there. And this is even though we have a much stronger factor, F6, in the use case. To rectify this, forcing to use the reason model. Now the reason model contains only a subset of the available factors. It represents a sufficient reason which, although it's not the strongest reason, is still enough to defeat the opposing reason. The losing rule still has all available factors, and the reason model has the same formal properties as the result model. But there are three problems. How to determine which factors constitute the reason? It's possible that cases are reinterpreted in the light of new decisions, which would disrespect the reason model rather than blame the results model. And even the results reason model does not constrain enough cases. Irrelevant distinctions are still possible. To find the answers to this problem, we look back to issue-based prediction, which was introduced by Steffi Bruninghouse and Kevin Apple. Whereas Plato was designed to generate arguments, not to predict outcomes. So it didn't matter whether there was constraint or not. the user evaluated the argument. But when case service is acted to prediction by Sheffield and Heaven, they found that HATO abstained on far too many cases. HATO is considering irrelevant distinction, like the unique product in the example earlier. So HATO instead considers cases issue by issue rather than as a whole. So IBC considers cases issue by issue. And this conforms nicely with the IRAC model, widely taught in law schools, where the analyzer case into the issue, the rule governing the issue, not the case as a whole, the application of the rule and the conclusion. So I would argue that thinking in terms of issues rather than cases conforms to this widely used method of visual analysis. The issues form a logical model. They're related logically, and so there's no need to balance them. Once the factors are resolved and the various least nodes are known, then we can infer the conclusion. So what is the role of factors? The role of factors is to determine the least of the logical model. Each issue is associated with a small group of factors. Factors can relate to more than one issue. And because fewer factors are involved at the issue level, the decision is much more likely to be constrained. There are 8,192 possible decisions for both the defendant and the plaintiff in case. So imagine the size of the lattice that we have to the past law. However, there are never more than 32 possible antecedents for any issue in IDP. And this enables us to ignore irrelevant distinctions. In the paper, I have a full worked example, but because of the time available, I will jump straight to the last page. The case in question is Boeing, which considers certain manufacture of aircraft windows, cockpit windows. There are a number of relevant precedents, national instruments, television, which is about a PBX, and Bryce, which is about software methodology. And we can see that these cases are in some respects similar to Boeing. Boeing is identical to television on the grounds of secrecy, and it's identical to Bryce with respect to the actual confidential relationship. None of the issues are in Boeing are opposed. Information valuable simply is accepted, and improper means of info used was established by the use of respective material. So we really want Boeing to be constrained because television solves the issue of secrecy, and Bryce solves a rational incident, which Bryce followed, solves the issue of confidential relationship. But on both the results and reason models, F1 will distinguish television, and F10 will distinguish Bryce and rational incident. It's only if we think in terms of issues that we can constrain Boeing using television for secrecy and national incident for confidential relationship. And this is what we've done. So the argument is that we actually need to incorporate the main knowledge, the knowledge of the factual cases represented by issues. This is because we want Mason and we want Bowen to be constrained by the precedent in the example. And issues are needed so that the irrelevant differences can be ignored and the cases constrained. Preferences are correctly located at the issue level. And this was recognized by Carl Branting as one of 1991, his paper, Losing the Portion Perspective. It was exploited by IBP in ICAO 2003, but it's still currently not exploited in the former House of Presidential Constraints, as represented by Henry's paper. Also, for explanation in terms of values, issues allow values of things to be local to issues rather than global, and the global requirement has presented problems in the past for value-based explanation. Now we'll come on to the third topic, factors of magnitude. Many factors seem to have a continuous favour. The number of disclosures from bulk to many thousands. The extent of security measures from minimal to draconian. The ease of research engineering. I know that at advance, but it may take me several years of study and experiment. The length of stay in various domiciles. And all these look like dimensions rather than factors. So how do they work with presidential constraints? This has recently been explored by the usual suspects, John Halsey, Adam McConey, Henry Patton, and even by myself to some extent. The question is, do we need to change our account of presidential constraints to accommodate dimensions? And our answer is no. Presidential constraints uses factors, not dimensions. And the reason for this is reasoning the precedent involves two stages. Firstly, we identify the factors, sometimes termed intermediate precedent in the literature, on the basis of facts. And we find this in jurisprudence, Rossi's taboo paper. We find it in AI and law, Ashley and Willinghouse. We find it in jurisprudence again with Lars Linger and Overflat. And we find it in AI and law in Patton et al. Identifying constraining precedents by comparing factors is the second stage. We got rid of the dimensionality in the first stage. Consider, for example, disclosures. The number of disclosures is a dimension, ranging from bulk to very many. However, the particular number of disclosures in a particular case is a fact. If it's no, the dimension is impossible, there's no factor. If it's a very small number, there is no factor because it's not significant enough. If there are many, the factor is less 10. And if it's in the public domain, the factor is X27, the very strong dependent factor. And of course, which factor applies may be determined by precedent. I also want to say something about trade-off. Sometimes factors are not independent. Look at the example from Patton and Sartor used by John Halsey. This concerns the same official's domicile. It depends on the length of stay and the percentage of income from abroad. The shorter the stay, the bigger the percentage needed. Absence and percentage are, as I mentioned, and in a particular case, the particular absence and particular percentage are facts. The factor is income sufficient with an absence. And once the factor is applied, we can apply presidential constraint to it in terms of facts. As an example, consider the trade-off between income and absence. There's question 1 at 66, question 2 at 28, and question 3 at 2010. Clearly, there's a trade-off because we have the same percentage, but a different factor because of a different length of stay. The precedents show that this area, the area to the northwest of the line, does not apply, and the factor applies northwest, but it does not apply southeast of that line. And so we can fit a line to show the trade-off. Several lines are popular. This one is most generous to the most generous. So,
Trevor,
to summarize, there are different roles for president.
sorry, Mr. Trevor, 5 more minutes, okay?
I've only got 2 more slides. There are framework presidencies identified by the Germany and the Ireland Law 2015. And these tell us what the issues are. And the issues can also come from statutes and documents that the statement before. Then there are restriction criteria, and these determine whether a factor applies on the fact. E.g., 12 months is a short stay, 3 years is a long stay. And we can use either the results or the reason model to factor restriction. Finally, there are traditional preference questions. These are the standard sort of questions found in paper. And these establish which side has to respond to these. And they may also indicate values. And that's all.
Now we have the questions and answers session. Mr. Trevor, the first question was done by Prakan, and the question is, does your account of factors and dimensions principles that for every value of a dimension, it can be determined which size it favors, if any?
Yes, a judge always has the power to say that this dimension favors this side or that side for the future. It may not be constrained by precedent, but if it's not constrained, a judge can and indeed must make the decision.
Okay, thank you, Mr. Trevor. And the second one is, can you think of difference on civil law and common law systems when analyzing decisions using precedential constraints?
Sorry, can you repeat that? I got a bit of noise here.
Can you think of difference on civil law and common law systems when analyzing decisions using precedential constraints?
In civil law, precedents are used more to guide than constrain, but the general reason involved is, I think, very similar.
Yes, and the last one, the role of issues in legal reasoning is similar to the role of values in deciding among competing factors.
Can you repeat that? Sorry. Can you repeat that?
Yes, I can say it again. The role of issues in legal reasoning is similar to the role of values in deciding among competing factors.
I'm not quite sure I think that. I think that values decide amongst competing factors, but factors compete to resolve an issue.
Okay, I think the last one, in providing further criteria for deciding among competing factors. I think it is the same question.
Okay. Thank you.
Okay, I think that's it. Thank you very much, Mr. Trevor. I really appreciate it.
Thank you. Sorry to be so much trouble.
Of course. So our next speaker is Masaharu Yoshioka, who I would like to introduce to the audience. And he will present the paper BERT-based ensemble methods with data augmentation for legal textual entailment in Colley statute law task. So Mr. Masaharu, you have 10 minutes of speech, and afterwards we will move on to the questions. The stage is yours.
Yes, thank you. Thank you, Chairman. My name is Yoshioka from Hokkaido University. Today, I'd like to introduce our research titled BERT-based ensemble methods with data augmentation for legal textual entailment. So in this talk, we would like to introduce our system that participates Colley 2021 task 4 statute law entailment task. This is the format of the data for the task. A pair of questions and articles are provided. The system should estimate the label for this pair by checking whether the article entails the question or not. In this case, answer is yes. So recent development of deep neural network tech-based NLP, these tools are also used for this task. In the last Colley, the best performance system uses BERT as a core module. BERT is a tool that can be used for semantic analysis tasks by the pre-training for general semantic understanding task using large text corpus. Based on this training, BART can be served as a general semantic analysis tool by fine-tuning with small training data. Even though the best performance system works well at the CORI 2020, but there are several issues remain. One big problem is lack of training data. We only have 3 small examples of 806 pairs. Another problem is variability of the question. The good performance system for the data of a particular year may not be good for the other year data. In order to tackle these issues, we propose a method to make new training data systematically, and we also propose a method that can handle variability of the questions. In order to make new training data systematically, we classify the type of mismatch for entailment. So this kind of data making process can be called as a data augmentation. That is a technique for machine learning by increasing the data using original data. There are 2 types of mismatch in the for making such a kind of pairs. This is an article. Is a judicial act performed by an adult word is voidable. So when we replace the adult word to adult, this is a semantic mismatch. We cannot entail the such kind of question from this article. Another type of mismatch is a logical mismatch, that is flipping the decision, adding not or removing not. It's not so easy to appropriate set of such semantic mismatch pairs, but it's much easier to make this type of logical mismatch systematically. Based on this understanding, we propose a method to create logical mismatch data systematically. For the positive example, we pick a pair of sentences about judicial decision in the article for the question part and article parts. The same sentences are used for these 2 parts. Negative examples are made by flip judicial decision of the sentence statement in the positive example to make logical mismatch. We flip the question statement. Most of the case, we add or remove not for the question statement for negative example. This is an example of making augmented example. This is the original statement. And from this statement, it says that may not. So we copy this statement to the article part. However, for the question part, we remove not from there. So because of that, this article cannot entail this question statement. So based on this training data, we train a BART-based entail system that is for original, that was proposed in the original BART paper. In this framework, BART estimates whether the question is entailed by the article as a binary classification task whose input is a combination of question and question and article with combinatory symbol set. The system calculates probability of entail or not as a result of the estimation process. So in order to understand the effectiveness of our proposed framework, we conduct preliminary experiments. This is a parameter of the BART is as follows. So we use BART Japanese model constructed by Inui's laboratory at Tohoku University with following parameters. We select minimum validation loss model using validation data. By using this method for 768 articles, so by using this data augmentation method, we construct 331 pairs generated as augmented data pairs. And we also split organizer-provided training data into training for the preliminary experiment, 695 pairs, and the testing for 111 pairs. And this training data are also split into training and validation, 9-to-1. So we all have, finally, we have almost 4,000 pairs for the training. 70 sentences for 70 pairs for the validation and 111 pairs for testing. In order to checking about the variability, we made 10 models using different randomly selected training set. This table shows the performance of the generated models using validation loss, validation accuracy, and the test accuracy. As we can see, the performance of the system are not so consistent, even though we use almost same framework for training the models. In addition, validation accuracy is not directly related to the performance of the validation accuracy and the test accuracy. So it is difficult to select appropriate model using validation accuracy and validation loss. In order to evaluate, based on this understanding, we try to make a proposal for making an ensemble models. In order to evaluate the effectiveness of this idea, we also conduct preliminary experiments for ensemble setting. In this experiment, we check performance of the combination of different models for ensemble. In this ensemble process, the average probability of positive and negative from the target model and select one whose probability is larger. We calculate accuracy for all combination of these 10 models. We select the pair set that uses 3 to 10 models from them. This table shows the result of the ensembled data. The best performance system uses 7 models, and the second and the third best system uses 3 models. On the contrary, the performance of the system using all models is worse among all settings. From this result, yeah.
You have 2 minutes.
Yeah, thank you. From this result, we found that simply adding of the model may not be good for improving the performance. So it is necessary to have a mechanism to select the appropriate set of models for ensemble. So we use evaluation data because these 2 sets are good for the testing of the training data. We're picking up these pairs for the one of the best performance system of the submission system. We submit 3 results with different ensemble setting. Our system achieves the best performance among all submissions. From 81 questions, we can answer correctly for 57 answers. The accuracy is at 0.70. And we also compare the performance of the accuracy of previous year's data. The model is not so consistent. However, when we compare the result of the system with other participant system, our 18 runs are submitted in total. It means these questions are almost all system can answer correctly. And these questions are questions almost no system can answer correctly. Our system is very good at making good answers for the easy question, but we still have a difficulty to answer that difficult question. This is an example of the difficult question that includes semantic matching, anonymization, symbol treatment, and so on. So BART model itself can handle some semantic information, but there are so much big semantic gap between this question and articles. In such a case, we fail to analyze such a kind of statement at this moment. So this is a summary of my presentation. We propose a statute law legal entailment system based on BART with making new training data that consider logical mismatch using systematic approach as data augmentation. we also propose a method for selecting appropriate set of bird-brain model for ensemble. We confirm the effectiveness of our approach using CREE 2021 test data. Thank you for listening. This is the end of my presentation.
Thank you, Mr. Yoshioka. And now we are going to the question and answer session. The first question is, for a legal perspective, is it possible to analyze and relate the outputs, yes or no, of your bird-based system to any possible legal explanation to that?
Yeah, it's a very important point we have to discuss. At this moment, since our system just say yes or no, so this is just a starting point, and maybe as you can see some neural network, deep neural network based analysis. Maybe we have to think about such a kind of attention. So these two parts may be related or something, can be lead to such a kind of explanation, but at this moment we cannot start such a kind of analysis. So yeah, at this moment, this is just a result without explanation. So we also think about how to generate explanation based on this result later.
Okay. And the second question is, can you think of difference between the Japanese judicial system to another law system in the world, like the American? And if you did, do you have suggestions of adaptations you could do to your work?
Yeah, so yeah, in the CORE task, we have a Japanese version of statute law task and the Canadian case law task. So the case law task have a much more case oriented. So most of the case, statute law only mostly contains the legal terms. The difficulty is a matching between the legal terms of normal terms exist for the cases. But case law matching, we also think about some matching of the normal terms and normal terms that consider the role of the judicial legal terms and so on. So the situation is not so, maybe it's not easy to say this is for American, this is for Japanese, but for the case law and the statute law, there should be some difference.
Okay, perfect. I think that's it because we don't have more time.
Yeah, thank you.
Thank you very much. I really appreciate it.
Yeah.
And now we are going to our next speaker, that is Ms. Sabine Wennert, who will present the paper Legal Norm Retrieval with Variations of the BERT Model Combined with TF, IDF, Vectorization. So, Ms. Sabine Wennert, you have 10 minutes of speech. And
yes.
Afterwards, we will move to the questions. The stage is yours.
Can you hear me? Hello? Yes, I think you can hear me. Okay, good. I will just start. Welcome to our presentation on legal norm retrieval with variations of the BERT model combined with TF-IDF vectorization. My name is Sabine Wennert, and together with my colleagues, we have also participated in the COLI competition. And our approach is for task 3 of the COLI competition, which is statutory law retrieval. So this task is about having a query that describes some situation or a statement simply, and you have to retrieve articles that are relevant with respect to that query. And this can be one or multiple articles. So the data set at hand that we used is the English version of the Japanese Civil Code, and we have fewer than 1,000 instances. And as I already mentioned, multiple articles can be relevant. So in the past 2 years, the best approaches were different. Sometimes it was a deep learning approach, sometimes it was a traditional machine learning approach. As we can see here that in 2020, the team LLNTU won with a BERT ensemble that comprised of 3 models. And then in 2019, the University of Alberta won with TF-IDF and lemmatization, as well as stop-word filtering. So that was the reason for us to combine those two approaches and see if they could benefit from each other. And also, since we consider here retrieval also as a problem of not so many instances in this data set, in this case, we also were thinking about approaches to increase the number of instances and also enriching their content. We submitted 3 different runs, and the first run was our winning run. And this is here an overview picture of the workflow. So we used sentence-BERT embeddings with TF-IDF, and you can see here on this picture that we have queries and articles, and that we pre-process them with different methods. So you can see that we have 2 stages of TF-IDF and then also sentence embedding. From that, we obtain the vectorized version of the article and the query, and then we compare those 2 with the cosine similarity after each pre-processing stage. And then finally, we compute the sum, normalize it, and then determine a threshold to have the final prediction whether this article is relevant to the given query or not. I would like to present you also some details on what we actually did. And the first thing I would like to present is the data enrichment. So consider Article 177 about acquisitions of, losses of, and changes in real rights on the movables, and so on. So this article is not that different from the other articles in the wording in the civil code. And we thought we could make it more unique by enriching it. So the first idea we had was to use the information that we could obtain from the civil code directly. So the civil code has some sections and headlines, and we just thought that we can take those as metadata and then simply parse them out. So you can see for this article 177, we could then get part 2, real rights, chapter 1, general provisions, and so on. And we simply took this text and appended it to the original article text and then further processed it using the tokenizer and the TF-IDF vectorization. And here you can see that we also added some other crawled data from open source commentary that was originally in Japanese, but we translated it using the Google Translator API. And this open source commentary was then for this article 177. And for example, there were some concepts defined such as comprehensive succession. So this was also just appended to the original article text. The third enrichment we performed was to use the information from the task 4 that was on entailment that just Mr. Yoshioka has presented. And there we know that for this article, there are probably some queries that have a positive entailment label. And since we know that the entailment somehow indicates that the meaning is the same of this article and the query, if this is a positive label, we thought that we can also use it for document enrichment. And so we also appended all queries that have a positive entailment label to this article. That was the data enrichment. Now we talk about the 2-stage TF-IDF. This is actually quite simple. So for both stages, we just used sublinear term frequency scaling and L2 normalization. And then the only difference between the 2 stages is basically how we enriched the articles. So stage 1 has the article with the metadata from the hierarchical structure of the civil code, and as well the article with the relevant queries from the entailment information. And stage 2 has only the metadata from the hierarchical structure. And at this point, you may wonder, well, why didn't you just take stage 1? And so we have made some comparison of just taking stage 1 and just taking stage 2. And there, usually the combination worked best. So on validation data, we saw much improvement. And on the test data of the Colli competition, we just had almost no difference between stage 2 and then the combination. So combining this didn't harm and also could give a benefit. And then finally, I would like to show you some details about the sentence embeddings we took and the thresholding mechanism. So the sentence embeddings come from a BERT model that's called sentence-BERT, and it has been proposed by Reimers et al. And here they have used the Siamese architecture that encodes the query and the articles separately, but then there's some parameter sharing between the weights that are then learned during the classifier training. And what we also used was a pre-trained model from those same authors that's called Paraphrased as the Roberta base. And this model is particularly well suited, according to those authors, for natural language inference tasks. And since this retrieval task is also pretty hard, we thought that it could also benefit from such a model. And then the thresholding, for this, we have taken a kind of hard-coded approach that also was then simply saying, okay, for some index value, we have a specific similarity threshold, and then this article is included if it fulfills this condition. So with this run, we achieved the first rank in the Collie competition with an F2 score of 72%. So precision and recall were quite high and balanced almost, and that's why we won in this case. There were other approaches that had a higher recall than we had, but well, F2 was then the measure that determined the winner here. And then let me just briefly also tell you about the other two runs that we submitted. One is Legal BERT with TF-IDF. There we used the BERT model as a classifier for retrieval. And as a basis, we used the Legal BERT-based uncased model. Well, and when you have a classifier for retrieval, you have the challenges of relevance class imbalance, because usually just a few documents are relevant and all the others in the corpus are irrelevant. And we also have the small data set. So this is quite a challenge for a deep learning approach. And what we did to make this a bit easier for our model was to decompose the data in the sense that since we know that there are instances that have one query and multiple related articles, we decomposed them in pairs of one query and one article. So these were then sometimes multiple instances. And also we kept the original one where we had the articles still glued together as another instance in the data set. And what we also did was to decrease the number of irrelevant articles by just choosing the top 50 most similar non-relevant articles to a given article, because it's maybe more like it's harder for a model to determine why are those articles not relevant, although they are similar to a given relevant one. So that was our approach here. This is just the pipeline, the final one, where we have the TF-IDF, cosine similarity, then max normalization, and then we perform the arithmetic mean between the values from the TF-IDF and the legal BERT. From the legal BERT, we have the softmax for the relevant class, and then we have also some final thresholding. With this approach, we achieved an average position. So we were position 9 here, an F2 score of 67%. Well, and here you can also see recall was high and precision was a bit lower. So probably more advanced methods and thresholding would have helped here. And maybe this approach would be even also better than our first run. And then very shortly, the last run, that's the BERT score. So that was a pretty easy thing that we did because it's based on an already available implementation. And what the BERT score does is that it simply computes the maximum pairwise cosine similarity between token embeddings that we obtain from a BERT model that is pre-trained. And so what you can see is that we have our training data, then we perform the BERT score computation, and we obtain an F1 score for the matching, and then we also just determine a threshold based on this F1 score. And here we were actually the last position, so we have the whole spectrum in the Collie competition. And with this, we can also see directly, if you look at the values, that the precision is pretty low, and this is the reason why we were so bad, because recall is actually quite okay, but we probably have made a bad threshold decision or also overfitting in this case. So just to conclude, we found that pre-training and model architectures can play a vital role in using BERT for retrieval, and in our case, task adaptation and architecture, as we have seen in run 1, were better than domain adaptation in run 2. And also adding TF-IDF to the model improved performance. And then further takeaways are that data augmentation, decomposition, and enrichment are useful. And we also found that BERT approaches require much tuning and experimentation. So if you try to recreate this from scratch, then you might not get the same results that we have, because there are random parts of the BERT model, and then learning can be very different if you start the process a second time. With this, I conclude my talk. These are some selected sources, and now I am ready to answer some questions.
Okay, thank you, Sabine. It was a really nice presentation and really interesting. So we have here one question. That is, one of your remarks was the benefits of incorporating external knowledge. In your opinion, what could be other structured external knowledge that could lead to an improvement in results or in explanation of its outputs? A rule-based knowledge could help on that in any way?
Yes, I think so. For example, we could try to find out how the query, like some characteristics of the query, if this query describes a particular situation, if there are person relationships, if we can maybe classify those persons as some kind of entity. So classification could help there, and also probably a rule-based one, just when some term is present. I think those rule-based approaches are very often also applied for the subsequent task of entailment detection, but probably for retrieval it would be also a valuable choice. Yes, and regarding explainability, I mean, this is also a deep learning approach, so we are rather on the lower end of explainability. The only thing we could do is to check activation values or also analyze subpopulations of interest. So if we want to find out some parts of the data set, maybe particular hard queries, if we are good at those, or queries that then also describe particular cases compared to cases where we just have a query that almost has a direct overlap with article text. So we could try to also segment the data set and then find out where we are actually good at.
Okay, so due to the lack of time, we will finish for now. So thank you very much. And now our next speaker is Hui Shu, who will present the paper Towards Summarizing Case Decisions via Extracting Argument Issues, Reasons, and Conclusions. Ms. Hui Shu, you have 10 minutes of speech, and afterwards we will move on to the questions. The stage is yours.
Okay, thank you. I'm gonna share my screen now. Okay. So can you see my screen?
Yes, yes.
Okay, that's perfect. So hello, everyone. It's a pleasure to be here. Today, I'm going to present our research paper of Towards Summarizing Case Decisions via Extracting Argument Issues, Reasons, and Conclusions. So I'm starting off the motivation of our project. Why summarizing a case decision is so important. The legal summaries are a necessary tool for legal practitioners to analyze a huge amount of legal material. Unfortunately, not all the decisions have the high quality summaries. The reason for that is simply because it's too costly to do that. So automatic legal summarization could help legal professionals and the public to access legal information with much lower cost. So in our study, we try to use our argument mining to improve the legal case summaries by picking up those sentences that comprise important issues, reasons, and conclusions. And we hired law school students to annotate those key information in expert prepared case summaries and for case decisions. There are two main contributions of our project. First, we employed an IRC type system for generating the succinct summaries. And second, we experimented an intermediate structure of mapping from a mapping of the key information IRCs from the summaries to the full texts. So what is a legal argument triplet? We segment a legal argument into three elements: issue, reason, and conclusions. We refer to this key information as legal argument triplets, RC triple for short. So presumably those expert prepared summaries will have those key information. The benefits of using the IRC triple would help to clarify the case decisions and make it more accessible and transparent to its audience. Besides, it's an example of combining legal domain knowledge with argumentation that could supplement the machine learning techniques. This is an example of summarizing case decision using legal argument triples. So in order to get a high quality annotations, we hired law school students to do annotation, followed a detailed annotation manual for us. The annotators would do the annotation individually, and then we would resolve any differences between the annotations through the Zoom meetings with consensus of both annotators. This is a screenshot of the annotation tool we utilize for the study. Annotators would simply use cursor to mark the sentences according to the annotation manual. We also ask our annotators to do annotation for the full text. Instead of asking them to read through the whole the legal case decision, they would pick up the keywords from the annotated summary sentences as pointers, and then use them to locate corresponding sentences in the full text. Then we resolve any differences between the full text annotations as the same manner as for the summaries. The benefits of using this strategy is to help us to gather a sizable data set in a short period of time. And also it is the first step of projecting the annotations from the summaries to the full text automatically. Cohen-Kappa coefficient is used to measure the degree of agreement between the two annotators. The mean of the coefficients across the all types in the full text is 0.827. Given our experience and the task, it indicates a reasonable agreement about the nature, the type of the sentence types. So our annotated data set is based on the paired cases and summaries we received from the Canadian Legal Information Institute. The uniqueness of these corpus is all the summaries are prepared by the legal experts. Those cases have very rich legal information since they cover different kinds of legal claims and issues. In the current phase, we have already annotated 574 summaries and corresponding full texts. This figure shows the distribution of annotated IRC type of sentences in both summaries and the full text. As you can see, the non-IRC type of sentences are the majority in our annotated data set, which make our data set imbalanced. However, the manually mapping from the annotated summaries to the full text is still a very time-consuming task. So we decided to experiment automatic mapping from the annotated summaries to the full text, which is intended to decrease the annotation cost and improve the annotation efficiency. The strategy we use here is utilizing sentence border embedding, which would help us to derive semantically meaningful sentence embedding with fixed size. Then we use the sentence border embedding to calculate similarity scores for the annotated summary sentences with full text sentences, and then only keep the top 5 sentences with highest similarity scores for the further use. The novelty here is we're trying to generate weak labels by deploying the state-of-the-art sentence border embedding. Those are examples of automatically mapped IRC, the issue, reason, conclusion sentences. As you can see, the top ranked sentences often include the same keywords as the manually mapped sentences. We also find the reason sentences have fewer overlapping keywords than the other types. For the study, we choose different kinds of deep learning models to experiment, like the LSTM, synonym BERT, and synonym BERT models. Since our data set is imbalanced, we're trying to remedy the imbalance issue of our data set by using different kinds of loss function. There are three kinds of loss function we use here: the cross entropy, focal loss function, and the F1 loss function. For comparison purposes, we train our models on manually mapped data and automatically mapped data separately, and the F1 score is used to measure the performance of our models. This table shows the results of our experiments. As you can see, after training on the manually mapped data, the LSTM has the better performance on identifying the issue and the conclusion, and the synonym have the better performance on identifying reasons. After training on the automatically mapped data, the LSTM has the better performance on reasons, and the synonym BERT has the best performance on identifying conclusions. What we can learn from the results of our experiments? In general, the model performed much better after training on the manually mapped data than the training on the automatically mapped data. And we also noticed that the different models have their own strengths of identifying different types of sentences. For example, the LSTM has better performance on identifying issues and conclusions, and the synonym has the better performance on identifying reasons. We also noticed that the precision score decreased after training on the automatically mapped data. Our intuition about the decreased precision has something to do with the quality of the automatically mapped data. For conclusion, we confirmed that the deep learning model performed pretty well on extracting the IRC triples from the full text. And the loss function could mitigate the imbalance issue of our data set to some extent. The results of the automatic mapping shows the possibility for the automatic annotation in the full text. For the future work, we will continue to increase the size of the annotated data set, since the data size is not large enough for final comparisons in terms of the model performance. We also will explore more effective methods to identify the issues, reasons, and the conclusions. Finally, we would like to explore the possibility of generating the summaries by employing the automatic annotation. Last but not least, I would thank the National Science Foundation for supporting our work, and the Center for Research Computing for providing the computing resources, and our partnership with University of Montreal Cyber Justice Lab and the Canadian Legal Information Institute for providing such a unique corpus for our study. Okay, thank you. So any questions?
Thank you very much, Ms. Xu. Now we are going to the questions and answers section. And we have some questions here. First, based on your investigations, what is the perspective to have better results from automated annotations?
So the first of all, I still will increase the size of the annotated data set. As I mentioned before, in the presentation, since our data set only comprised 574 the annotated cases, so it's not especially for the deep learning model, it's not large enough to give a very promising results. So the first thing we will do would be increasing the size of the data set.
Okay, and the second question is, when searching for annotation tool, which one did you choose, and why have you chosen it, and which limitations has the annotation tool?
Oh, the annotation tool. I have to thank for the second author, Jaromir. Actually, he is also of our annotation tool. It's personalized or designed for our specific task. This is the annotation tool we designed by ourselves. So it's not something you could search online. So generally, we have very nice experience of using this tool, and very nice. And you can see the screenshot I presented before. The layout of the annotation tool is very simple. The text column in the middle would be the annotators to annotate all the sentences for us. And there's a little menu would pop up if they select the sentences with 3 options. They would simply choose one of the options. And the sentences will mark the different colors according to the different types of sentences. Very easy to use.
Okay. Thanks. So I think that's it due to the lack of time again. So
okay, thank you very much.
I thank you very much for the presentation. It was really good. And okay. So we are going to our last speaker of this panel, which is Mr. Joe Colonet, who will talk about the paper From Formal Models to Implemented Tools, the ACHR as a case study. So Mr. Joe Colonet, you have 10 minutes of speech, and afterwards we will move on to the questions. So the stage is yours.
So thank you. My name is Joe Colonet, and I'm going to present this work, which I completed with Katie and Trevor from the Department of Computer Science and Constantine from the Liverpool Law School. So just to give you a bit of an overview, I'm going to start off with an introduction to our work, including some of the motivation about why we've chosen admissibility of cases as the problem to tackle. I'll then discuss how our model was implemented, both as a concept and practically. And then finally, I'll discuss the pilot study where our implemented program was used by a small sample of lawyers who work in the European Court of Human Rights. And then finally, I'll take some questions at the end. So we've developed a model that determines admissibility of cases that are submitted to the European Court of Human Rights. Admissibility in this case is whether the court will look at that case. And then if it's not admissible, then they don't look at it. And once our model has determined whether a case is admissible, it explains how it came to that decision. This is then implemented into a Java program and then we've obviously conducted a pilot study where we've given our program to a small group of lawyers. So just a brief introduction on the European Court. It was established in 1959, and it makes judgments on whether a member state has breached the European Convention on Human Rights. Decisions are mostly based on previous cases, such as in case law, but there is no specific requirement for the court to follow that in practice. So we've chosen admissibility specifically rather than the outcome of cases, as this is a major issue that the lawyers that we've spoken to have identified. So to kind of show you the scope of the issue, in 2019, there were 45,500 applications, approximately, submitted to the European Court, but only 90% of these were declared inadmissible. Only a small proportion of cases actually get to a point where a judgment needs to be made. And there's currently 50,000 cases in the European Court's backlog. So being able to speed up the ability to decide admissibility would massively improve a person's access to justice in Europe. So our model has been implemented as an abstract dialectical framework, or an ADF, using the angelic methodology, which represents case law as a factor-based hierarchy. So you can represent this as a tree structure, and at the root node, you'll have a violation, and then you have some children, which are the issues, and then but the children of those issues would be the factors, which can be base level factors or abstract factors. And each node in this tree will have some acceptance conditions to say whether that abstract factor issue is accepted. So for the legal foundations of our model, we looked at admissibility, and to decide that we need to know whether it's within the jurisdiction of the European Court, and the European Court has a set of formal rules that every application needs to meet. And these are things such as the application needs to be submitted within 6 months of the violation happening. It can't be a trivial case. And by trivial, there are some exceptions. And it's the same with anonymous applications. Normally they don't accept them, but in some special cases they may accept them. And there's a whole list of other rules as well. So here's our example of an implemented model. So at our root, we have the node V1 that represents whether a violation of admissibility has occurred. And this is accepted when the two issues I1 and I2 are also accepted. And then issue 1 is accepted when the two base level factors and two abstract factors are accepted. Base level factors are represented as questions which reveal a fact. Abstract factors can have other abstract factors or base level factors as their children. So this was all implemented in a Java interface, and it asks each of the questions from before, one after the other, until a decision can be made. Once the decision is made, it then gives gives the answer out, and it also gives the explanation as to why it came to that reasoning. And all questions are phrased as yes or no questions. So here's an example of what would happen at the end. So you get the so the decision's at the top, and then the explanations in the text box underneath. So in this example, the application won't be registered, and that's because the applicant doesn't have legal representation. The application form wasn't signed, so these would have been base level factors, so questions that would have been given, and we can infer through the issues that not all signatures have been provided, and that the application doesn't comply. Now, obviously, the ADF is a lot bigger, but we only when we generate our explanation, we only take the parts that the user have answered and is actually relevant to the decision that's made. So we don't just show everything in one go. So when we finished making this, we sent it off to 4 lawyers who work within the European Court of Human Rights. And once they had a play with the program, they completed a survey which had 11 multiple choice questions. And these questions, you could have a positive or negative result. So it's to strongly agree, disagree, strongly disagree. And these covered things such as functionality, usability, explainability. So whether the program functioned, how usable the program was, what they thought of the quality of the explanation, how useful they would find the program, and what they thought of the questions that we posed within our program. And so in our results, we had largely positive across the board, which was very nice to see, even though there's very few. And to conclude, so obviously we had some very positive results from the lawyers, and we can generally take away that lawyers do want technology to help them with the issues that they are facing. But they're also not computer experts, so we can't have anything that's too complicated or difficult to set up. So our future developments have tended to lean towards web-based systems. Okay, thank you very much for listening, and I'm happy to take any questions.
Okay, thank you very much, Mr. Colonet. It was a really good presentation, lovely.
Thank you.
And about the questions, when working with the experts, which you think were the main limitations to cooperate with them to do the work?
So when we created the questions, I first went through the booklet that they give to lawyers to explain how admissibility works, and then I created a set of questions, and then I spoke to them, to the lawyers about it. It generally went well. The biggest difficulty was finding things that weren't explained to in the documentation that was given. So there was often hidden things. It's usually some exceptions to the questions that were given that needed to be added in. So it's usually trying to find little finicky parts of the law that, as a lawyer, you don't really understand.
Ah, okay, I get it. Another question is, this work was modeled, think about case law judicial system, right?
Yeah.
Or so have you? Okay.
So yeah, it is case law for the most part for the European Court, but they're not bound to it. So they will typically, in almost all cases, they'll refer to a previous case, but there have been some. It's usually when it's a massive change in. So whether I think it's things like whether homosexuality is allowed to be in a same-sex marriage, things big changes like that tends to be where it doesn't rely on case law.
Okay, that's nice. And what do you think about the future of this work? Which will be ultimate goal, let's say?
So what we've been working with is trying to find ways of the lawyers or users, so people who apply to the court can then use this program. We're trying to simplify some of the questions, make it easy to users, so that instead of submitting this case and then it gets put into the backlog before someone generates it, they can then see how to make a good application, if you like, to the court. And they will be able to understand it a little bit better. And the court then gets better quality applications.
Okay, that's really cool. Okay, so I think this is it. It is the end of the presentation and the end of the panel. So thank you very much to all the speakers, Mr. Bench Kapun, Mr. Yoshioka, Ms. Sabine Wennert, Ms. Shu, and Mr. Joe Colonet. So now we will have a short break of 30 minutes, and we will see you in the event. So thank you very much, and now we will have the break.
Greetings, everyone. Welcome to 18th International Conference on Artificial Intelligence and Law. I am Aline McQueen, and this is the 6th panel of the second day of the event. Also, in name of the conference organization, I'd like to thank our platinum sponsor, Jus Brasil and Albert Einstein Israeli Hospital. Our gold sponsor, L'Algorithm, Legal Code, and PG Lawyers. And your silver sponsors, Urbano Vitalino Lawyers and Opsi Bloom Lawyers. And Ways is open. Now, I would like to introduce Mr. Hein Jain, who will present the full paper streaming with the title, Hardness of Case-Based Decisions, a Formal Theory. Afterwards, we will move on the questions. The stage is yours.
Yes. Hello, everyone. My name is Heng Zheng. I'm a PhD student from the University of Groningen. Today, I'm going to talk about our paper, Hardness of Case-Based Decisions, a Formal Theory. Following precedence is a fundamental principle of case-based reasoning, but the application of it varies in complexity. Legal decision-making can still be very hard. This puzzle has been well recognized in AI and law since its early days. For instance, in Anne Gardner's landmark work, An Artificial Intelligence Approach to Legal Reasoning, she addresses the distinction between hard and easy cases by using ideas from jurisprudence. The hardness of case-based decisions can come in different types. Some cases are easier to decide. However, things can become harder. For instance, not all conflicts can be resolved, or there is no matching precedent. Significant work has been devoted to the nature and dynamics of case-based reasoning and to the hard cases as well. However, to the best of our knowledge, no formal theory about the hardness of cases has been proposed so far in the field of AI and law. So in this paper, we are going to discuss this question. Is there a typology of how hard it is to make a decision about an issue in case-based reasoning? We propose a formal approach written in propositional logic to formalize the hardness of decision-making issues with the validities of relevant arguments. We also illustrate the approach with a case study in the dynamics of case-based reasoning by following Berman and Hafner's research, thereby showing how hardness varies over time. This slide shows the 7 cases that we are going to discuss, which aims to solve tort cases about car accidents from New York. With the elements extracted from these cases, we got 7 conjunctions to represent them. They are represented by the plaintiff's name, the year of the decision, the kind of case, either a tort case or a contract case, and the jurisdiction choice rule. We need to consider which rule should be applied when different jurisdictions are relevant. For instance, when people drive from New York and have an accident in Ontario, Canada, which rule should be followed? Ontario's rule or New York's rule? Your territory is for entirely applying the territorial rule. Exception is for partly applying the territorial rule while making an exception for the damages part of the case. And gravity is for applying the center of gravity rule. In this paper, we try to apply our approach to solve problems such as if there were only these two precedents can be considered, how hard it is to apply the territory rule in an undecided tort case that arose after 1945. And what about the hardness of applying the center of gravity rule? And after new cases were added, does the hardness of applying rules change? And does it become harder or easier? In general, we consider these four issues of the New York cases, namely whether to apply the territory rule in tort case or not, whether to apply the gravity rule in general, whether to apply the exception about the territory rule, and whether apply the gravity rule in tort law. As you can see from this picture, there was an agreement in decisions that the territory rule should be applied in 1938, so decision-making was easy at that time. However, from 1945, alternative possibilities were explored. First is for contract cases, then also for a tort law case called the Cuba case in 1961. Therefore, case-based decision-making becomes harder since there are different possibilities and without a clear preference. And then in 1963, things again became easier since the landmark Babcock case expresses a clear preference for the gravity rule. Now we turn to the theory part of the paper. First, we are going to introduce case models. We describe a case model C as a set of logical consistent incompatible cases, forming a total pre-order that represents a preference relation among the cases. For example, the New York cases we just introduced can form a case model. And please notice that we consider the plaintiff names to exclude each other pairwise. And similarly, for the decision years, the kind of the cases and the rules. The preference relation among these cases is denoted by the size of these boxes. And namely, the Babcock case is more preferred than other cases, which are equally preferred. This is because the Babcock case is a landmark case that overrides previous cases, by which the center of gravity rule is established for tort law. And we consider an argument from chi to rho is a pair chi-rho, where chi is the full premise of the argument, rho is the full conclusion, and chi and rho is the full position made by the argument. According to the preference of a case model, arguments can have three kinds of validities in the model. From weak to strong are coherence, presumptiveness, and conclusiveness. The relation between these validities can be illustrated by this Venn diagram. Conclusive arguments are also presumptively valid, and presumptive arguments are also coherently valid. And all the precedents are either coherent or incoherent. If an argument is incoherent, then it is outside the set of coherent arguments. Every argument can be attached to a label based on its validity in the model. An argument with a conc label are those conclusive arguments. An argument with a press label is an argument that are presumptively valid, but not conclusive. An argument with a co-label is coherently valid, but not presumptively valid in the case model. And label in co is used for arguments that are not coherent. These arguments are in the set of all arguments, but not in the set of coherent arguments. We consider the validity labels come with an ordering. Intuitively, based on their validities, arguments with label conc are stronger than arguments with label pres. Similarly, pres is stronger than co, and co is stronger than in co. With this ordering, we can quantify how far apart the labels are. We call the validity distance between two arguments is the number of steps in the validity ordering that are needed to go from the label of the weaker argument to the label of the stronger one. As the ordering has a length 3, the maximal validity distance is 3, and the minimal is 0. For instance, from con to in co, the distance is 3, while from co to co, the distance is 0. With arguments and their validity labels, we can define issues for discussing the question about hardness. Formally, we represent an issue as sigma plus minus iota, where sigma is a sentence for a given situation. Iota is a sentence as an issue about the situation. Both iota and not iota are not logically implied by sigma. For every issue, there are two naturally associated arguments, namely sigma iota and sigma not iota. For example, when we think of whether to apply the territory rule in tort cases, we consider issue tort plus minus territory, where argument tort territory is for applying the territory rule, and argument tort not territory is for not applying the rule. Similarly, whether to apply the gravity rule in tort law is connected with issue tort plus minus gravity. Whether to apply the exception about the territory rule is connected with issue tort plus minus exception. And whether considering gravity in general is represented with issue tautology plus minus gravity. The type of an issue sigma plus minus iota in the case model C is represented as a multiset consisting of the validity labels of the two associated arguments. For instance, if the argument for applying the territory rule is with label conc, and the argument for not applying the rule is with label inco, then the issue tort plus minus territory is with type conc inco. And by the definition of arguments validity in our paper, not all types are logically possible. Now we show in total 7 possible issue types. And we view hardness of issues, of types of issues, as a relation between types of issues in different case models. Intuitively, a type of issues is easier than another one if and only if the greater the difference between the validity of its associated arguments, or the stronger the validity of the associated arguments. For instance, conc inco is easier than pres, since the difference between conc inco is greater than the difference between pres. And since the validity strength of pres is stronger than INCO. We consider press is easier than INCO. As shown by the Haas diagram, in our definition, an issue type that is higher in the ordering is easier. Formally, the hardness ordering is based on the lexicographic combination of two orderings among the types of issues. We first compare the types in D ordering. Higher types in D ordering involve further validity distance between the labels within types. And higher in D ordering means the type is also easier. For instance, the validity distance between Kong and INCO is 3, and the distance between press and INCO is 2. Therefore, by the D ordering, we consider Kong INCO is easier than press INCO. However, if the types are with the same validity distance in D ordering, then we can turn to the V ordering. Higher in the V ordering means issues involving stronger arguments. Therefore, higher in the V ordering means the type is also easier. For instance, the validity distance of both type press and co are equal to 0. In this case, we cannot compare their hardness in terms of the D ordering, and we need to use the V ordering to decide which one is harder and which one is easier. Since press is stronger than co in the V ordering, we consider press is easier than co. The Haas diagrams in this slide shows our definition of hardness is well-behaved, since it is transitive and can be used for comparing any pair of issue types. Now we connect the hardness ordering with the development of hardness of applying rules in the New York cases. As we discussed before, the hardness of an issue is determined by the validity of arguments that it associates with. And with new cases being added, the hardness of applying rules will change accordingly. For instance, the hardness of issue taught plus minus territory is with type Kong INCO in 1938. When it becomes harder in 1963, it is with type press co. In general, we figure out that when the gravity rule was introduced in general in 1954, issue tautology plus minus gravity became harder. Similarly, when the gravity rule was introduced to the tort law domain in 1963, issue tort plus minus gravity also became harder. And we also observed that issue tort plus minus territory became harder correspondingly when the court showed doubt on the territory rule by making an exception for the damages part of a tort case in 1961. And in 1963, when the gravity rule was introduced by a landmark case called Babcock case, with higher preference, not only issue tort plus minus gravity became harder, but also other issues are become easier. After finally making the...
Hank, you have 5 more minutes, okay?
Okay. After finally making the gravity rule as the primary one in 1963, the 4 issues remain the same hardness type press co as in 1938, when the primary one is the territory, and they are all with type Kong INCO. This shows that more options makes the consideration of applying rules becomes harder than in 1938. So in conclusion, we model the hardness of issues of case-based decisions in terms of arguments and their validities, and define an ordering that shows which issues are harder and which is easier. We also apply our approach to discuss the hardness of the issues in the context of dynamics of case-based reasoning. So the hardness approach we introduce is relevant in the understanding of case-based decision-making and can be applied in other domains where example-based reasoning is reasonable. And it can also lead to insights on the hardness of decision-making in hybrid AI systems involving both knowledge and data. Thank you for your attention.
Thanks for your presentation. We have a question. In the last part of your article, you have discussed the idea of the workings Herculean judge and counterpointed it with the existence of a variety of options to solve the cases we may have at hand. My question regards to the possibilities of more than one acceptable way to solve the case. Wouldn't this create a legal uncertainty in the courts?
Sorry, could you please repeat the questions?
Okay. In the last part of your article, you have discussed the idea of the workings Herculean judge and counterpointed it with the existence of a variety of options to solve the case we may have at hand. My question regards to the possibilities of more than one acceptable way to solve the case. Wouldn't this create a legal uncertainty in the courts?
Oh, yes. Thank you for the questions. That's for the, if I understand correctly, you mean there is a statement in our discussion sections. That's for the very initial observations of our approach. So I think that could be interesting for future research. Thank you. And I would also like to make a further response to one of the questions from my early presentation. It's from Professor Henry Bracken and about a paper from Thomas Gordon's 1991 paper and Bracken's 1993 papers. So comparing our approach to Gordon's work, our definition of issues share a similar intuition with his notion, but the mechanism behind our approach and his approach is quite different. And in Gordon's work, he simply distinguished cases into two categories. However, in our approach, there are 7 kinds of hardness. For Henry's work, he also connects hard cases with 2 arguments of which their conclusions are opposite, which is similar to our definition. But the purpose and the applied theory of his paper and ours are different. We have a special focus on how to formally identify the types of hardness, while it seems that Henry doesn't formalize the hardness directly. But we all still really thanks Henry's questions. It's very valuable to our further research. And yes, please. Now I'm ready for further questions. Thank you.
Thank you, Mr. Heng. Now I would like to introduce Ms. Lucia Zheng, who will present the full paper with the title, When Does Pre-Training Help? Assessing Self-Supervised Learning for Law and the Case-Hold Dataset of 53,000 more legal holdings. Ms. Lucia Zheng, you have 20 minutes of speech. Afterwards, we will move on the question. The stage is yours.
Hi, thank you. Let me just share my slides. Okay, all right. Hi, I'm Lucia Zhang, a master's student in computer science at Stanford University. My co-authors are a team of interdisciplinary researchers at Stanford. Neil Guha and Peter Henderson are JD PhD students in computer science. Brandon Anderson is a data scientist, and Daniel Ho is a professor of law and political science at Stanford University. Today, I'll be presenting on our paper, When Does Pre-Training Help? Assessing Self-Supervised Learning for the Law. In this work, we aim to establish a set of NLP benchmark tasks for the legal domain and explore the conditions for which domain-specific pre-training may be worthwhile. It has been said that NLP has hit its ImageNet moment with the rise of large language models like BERT. However, curiously, existing work has reported marginal gains for pre-training large language models on law, particularly compared to the much more significant gains achieved by domain-specific pre-training in other fields, such as biomedicine and computer science. As an example, consider the core NLP task of text classification. The Chalkaitis work, one of the most comprehensive existing evaluations of pre-trained language model performance on legal NLP tasks, finds that the macro F1 gain of BERT pre-trained on law over base BERT is only 2.5, and the gain is even smaller for other tasks like named entity recognition. In contrast, the authors of the SciBERT paper showed that a BERT model pre-trained on scientific text with a custom scientific vocabulary achieves a 7.07 gain in macro F1 on a text classification task. It's worth noting that some of the large differences reported in related work like BioBERT compare BERT pre-trained at 1 million iterations and a domain-specific pre-trained model on top of BERT at 2 million iterations. And therefore, the result may be confounded by this. In light of work by the authors of Roberta, which suggests that BERT was significantly undertrained and can achieve higher performance by simply pre-training the model longer. We'll discuss how we address this issue more in our evaluation. So this all leads to the question, why have such large gains from domain-specific pre-training not been observed in law? We hypothesize that existing benchmark legal NLP tasks are not adequately difficult enough to satisfy the conditions under which significant gains from domain-specific pre-training can be observed. This may be due to the expense of hiring lawyers with legal knowledge to manually label datasets for difficult legal tasks. As a result, many private companies are unlikely to make investments in labeling unless it is for solvable tasks. So existing legal NLP datasets are not only small or proprietary, but also tend to reflect lower difficulty tasks that have been solved by methods often predating the rise of self-supervised learning and models like BERT. Armed with this hypothesis, we set about trying to construct a new large labeled dataset for more difficult legal NLP tasks. As mentioned, this is often quite expensive due to human annotation costs. So we ask ourselves, instead of relying on expert annotation, can we extract signals from case law language in a systemic way to create a task? It turns out that the answer is yes, and this is because of one of the unique aspects of case law language, that it is stylistically governed by the Blue Book rules of legal citation, which set a standard for how legal citations appear in case law. This brings us to our key idea. We could create a multiple choice question answering task by leveraging these standardized rules to extract holding statements in case law. Holdings express governing legal rules when law is applied to a particular set of facts. They are precedential, which means they are what litigants rely on for subsequent cases. In case law, holdings follow legal citations and frequently begin with the keyword holding in parentheticals, as this format is strongly recommended by Blue Book. Using this idea, we created a new benchmark dataset, casehold. The next slide shows one example from the casehold dataset. On the left in gray is a citation and its citing context. We replace the location of the holding statement in the citing text with a holding token in brackets. On the right are the 5 multiple choice options for the citing text. The green boxes are incorrect holding statements matched with the citing text prompt, and the green box contains the correct holding statement that corresponds to the citation in the case law. This dataset has around 50,000 examples, comparable in size to other general domain NLP tasks, such as SQUAD and SWAG. To construct the casehold dataset, we extract all citing context, citations, and holding statements from a holdout set of the Harvard Law corpus, which is around 10% of the total corpus. We use the other 90% of the corpus for pre-training models, which we'll discuss in more detail in a few slides. Each example in the dataset consists of a prompt formed from the citing text and citation, one correct answer, which is the true corresponding holding statement found in the original text, and 4 semantically similar but incorrect answers, which are other holding statements sampled from the pool of all extracted holding statements. To match a prompt with 4 incorrect answers, we calculate the TF-IDF similarity between the correct holding statement and the other holding statements and match the prompt with the other holding statements with high similarity. We also set an upper threshold for similarity to prevent the matching of holding statements that parrot or paraphrase the true holding statement, which would make the task impossible. We also evaluate our model on 2 other benchmark datasets. The first is the overruling dataset, which simulates a binary classification task to determine whether a statement is overruling or not. This dataset is fairly small, consisting of 2,400 examples, and was created by Casetext, a company that collaborated with our team to release the dataset publicly. The second is the terms of service dataset, which also simulates a binary classification test to determine whether a consumer contract term is potentially unfair or not. This dataset was manually labeled by legal experts and contains around 9,400 examples. It was created by the authors of the Claudette paper cited on this slide. Next, we'll talk about the methods used to evaluate these legal benchmark tasks. To begin, we'll introduce the central BERT transfer learning paradigm, which we use to train our domain-specific models for law. This learning process consists of 2 steps. One is unsupervised training of large amounts of unlabeled text. In the case of base BERT in Devlin et al., the original paper, this is a general domain books corpus and Wikipedia. But as we'll see, this can be domain-specific text as well. BERT is pre-trained on this unlabeled text using 2 training objectives, masked language modeling and next sentence prediction. For the MLM objective, BERT masks random tokens in the input text and predicts the masked token. For the NSP objective, BERT predicts whether in a pair of sentences, the second sentence is the subsequent sentence of the first sentence in the original text. The second step is supervised fine-tuning on a specific downstream task with a labeled dataset. Using casehold as an example, we feed BERT citing text prompts as input and train BERT to predict the correct holding statement from the 5 answer choices. We trained several models using this framework. For our baseline models, we trained a 1-layer bidirectional LSTM initialized with 300-dimensional word-to-vec embeddings. For our baseline BERT model, we used the base BERT uncased model with 110 million parameters from the original BERT paper by Devlin et al. We also train a BERT double model initialized with base BERT parameters and pre-trained for an additional 1 million steps on the general domain Wikipedia corpus used to train base BERT. BERT double provides us with a model that is pre-trained for 2 million total steps for direct comparison against our legal domain-specific BERT models, which are also pre-trained for that many steps, addressing the confounding issue discussed earlier. Legal BERT is initialized with base BERT parameters and pre-trained for an additional 1 million steps on the case law corpus, the 90% of the Harvard Law corpus introduced earlier. But it uses the same general domain vocabulary as base BERT. Custom legal BERT is pre-trained from scratch for 2 million steps on the case law corpus with a custom legal domain-specific vocabulary constructed using sentence piece on a subset of sentences from the case law corpus. With some initial exploration of model behavior, we can see the significant benefit of a domain-specific pre-training corpus and vocabulary for legal domain-specific reasoning. Let's take a look at a couple of examples. Here's a quote by Justice Marshall from Marbury v. Madison. "The very essence of civil liberty certainly consists in the right of every individual to claim the protection of the laws whenever he receives an injury." We can transform this quote for masked language modeling by masking out the last word, injury, and feeding this input to our BERT model. We would like the BERT model to correctly predict that the masked word is injury. We observe that base BERT and BERT double do not predict the correct completion within the top 5 completions with highest likelihood. I think base BERT predicts action and BERT double predicts emergency. But legal BERT predicts the correct completion, injury, correctly. This demonstrates that domain-specific pre-training on legal text significantly improves model accuracy for tasks for which the pre-training text provides relevant knowledge, in our case, case law. Custom legal BERT predicts correctly as well, though this is not pictured in the slides. As another example, take the definition of the word affidavit from WEX, the Cornell Law School Legal Information Institute Legal Dictionary and Encyclopedia. Here, we transform the input by masking the defined word affidavit and have BERT predict this masked word. We observe that our BERT double and legal BERT models predict that the most likely word is oath, which is similar in meaning, but not as technically precise as affidavit. Custom legal BERT, on the other hand, predicts the correct word affidavit and attributes high likelihood to this prediction. We see about 80%. Affidavit is in the legal domain specific vocabulary for custom legal BERT, but not in the general domain vocabulary of BERT double and legal BERT. This suggests that the custom vocabulary contributes to additional gains beyond those from domain-specific pre-training only, especially for tasks that contain highly domain-specific terminology. We zoom out a little now to briefly discuss the details of unsupervised pre-training and supervised fine-tuning procedures we used for evaluation, and then we will present the results of the base setup and some variants. We use the pre-training procedure detailed in Devlin et al. With a few adaptations for improved performance on legal texts. One adaptation we implemented was a custom sentence segmenter that uses regular expressions based on Blue Book rules to keep legal citations together for next sentence prediction pre-training. This change was important because traditional segmenters use period characters as sentence delimiters, but there are many non-sentence delimiting periods in case law. We also used whole word masking for the masked language modeling pre-training objective. This change masks whole words rather than subtokens, forcing BERT to predict entire domain-specific terms, which are often not present in the general domain vocabulary and therefore frequently tokenized into subtokens. For fine-tuning, we use the input transformations presented in Radford et al., which allow us to train on different downstream tasks while making limited adjustments to the model architectures. Here, the green model box represents the section of the pipeline where we can slot in any of our previously described pre-trained BERT models. We'll go through the multiple choice question answering pipeline in a little more detail here, but the classification pipeline is similar. Using casehold as an example, we transform a particular example from the dataset so that the prompt is concatenated to each answer choice separately and separated by a start, delimiting, and end token. We feed each independently to the pre-trained BERT model we would like to evaluate, and this output goes through a classification head composed of a linear layer and softmax to produce a prediction of which answer choice is correct. The text below the diagram shows how this would be done for the original caseload example presented earlier. The following base setup results use this pre-training and fine-tuning procedure to evaluate the 3 benchmark tasks with tenfold cross-validation. We report average macro F1 as our performance metric. We observe that the baseline model performance for overruling is high. This is likely because the overruling task is comparatively easy. The task reduces to identifying the presence of keywords like overruled and disapprove in many cases, as these keywords commonly appear in overruling sentences. The baseline performance on terms of service and caseload is lower, which tells us that these tasks are more difficult and cannot easily be solved with a BILE-STM or base BERT. We see that BERT double and legal BERT achieve marginal gains over base BERT for overruling, which substantiates our earlier hypothesis that existing legal NLP tasks may not be sufficiently difficult to observe significant gains from pre-training language models on law. We see that BERT double achieves much higher F1 on terms of service compared to base BERT, but that legal BERT is not necessarily more performant for this task. This is likely because though terms of service is a more difficult task than overruling, the task language is extracted from consumer contracts, which contains more common language and less language similar to case law. In contrast, there is a 5.7 gain in F1 between BERT double and legal BERT, which suggests that the casehold task is both adequately difficult and domain-specific enough to satisfy the conditions for which more substantial gains from domain-specific pre-training are observed. Lastly, we see that custom legal BERT achieves the highest performance on all three benchmarks. The F1 scores are bolded in the table. In particular, we see additional gains beyond just domain-specific pre-training from a custom domain-specific vocabulary, as reported in other domains outside of law. We also attempted to define a more quantitative measure of domain specificity, which we call DS score. It is computed by taking the average difference in pre-train loss between legal BERT and BERT double over the dataset evaluated on the downstream task of interest. If a DS score is positive, this implies that legal BERT with legal domain-specific pre-training is able to reason more accurately about the task compared to BERT with general domain pre-training before any fine-tuning. These DS scores are reported in blue here. We see that the rank order of the DS scores matches our qualitative understanding of the domain specificity of the three tasks, with terms of service being the least domain-specific and having the lowest DS score, and casehold being the most domain-specific and having the highest DS score. We also evaluate the model on a few task variants. We discussed one of them here, and the rest are included in the paper. For the train volume variant, we vary the size of the casehold training set. This plot shows that legal BERT dramatically outperforms BERT double in precisely the setting that is relevant to law, where there is limited labeled training data. In conclusion, we present a new legal NLP dataset, casehold. This dataset illustrates the advantages of leveraging domain-specific knowledge, the standardized Blue Book format for holding statements in case law, to construct legal NLP datasets. Using casehold, we show gains from pre-training language models on law comparable to the largest gains reported by CyBERT and BioBERT. We hope this contribution drives excitement and interest in solving more difficult legal NLP tasks. Additionally, we outline two conditions that help identify where domain-specific pre-training may be worthwhile: task difficulty and domain specificity, and offer some ideas such as DS score about how to quantify these qualities of a task. This may guide practitioners in deciding when resource-intensive pre-training is necessary in the future. We close by sharing some resources. The legal benchmark datasets and the code for fine-tuning to replicate reported results are available at this GitHub link. We also invite you to download and explore our pre-trained language models for law on the Hugging Face model repository. You can explore model behavior using the Marbury v. Madison and the affidavit example from the slides, or any other descriptive examples of your choosing in the browser on the Hugging Face model pages. Thank you for listening. Neil and I are happy to take any questions, and our contact information is also on this slide.
Thank you, Ms. Lucia. And we have a question. In the section of related work in your paper, you have mentioned the possibility of selection of bias in available legal and NLP datasets, and this becoming one of the risks in the rise of self-supervised learning. What could be a solution of the control of the bias in the usage of self-supervised learning, and which are the risks we are facing with the non-usage of those solutions?
Yeah, so I think the question maybe is referring a little bit to the bias towards, let's see. Yeah, the bias of like towards simpler NLP data sets like being existing in the public, and the reason for that being that it is expensive to actually annotate legal NLP tasks specifically, because you have to pay lawyers with very expert like legal knowledge. And so one thing we sort of suggest in this paper that might help alleviate that issue with the cost is trying to extract signals based off the specific rules of like case law, or maybe based off any other formats of legal texts that are standardized, in order to do this in an automated automated fashion. And in that way, we can make large data sets much more cheaply for maybe tasks that are also more difficult, like something like multi-class classification or multi-label classification. So that can help. I think maybe another answer to that is more collaboration between these like companies and outside independent researchers, which may encourage like work towards that.
Thank you, Ms. Lucia. We don't have any questions, more questions. Well, now I would like to introduce Mr. Antonino Rotolo, who will present the short paper with the title, Modeling Legal Procedures. Mr. Antonino Rotolo, you have 10 minutes of speech. Afterwards, we will move on the questions. The stage is yours.
Thank you very much. I share the screen. Here we are. Okay. I hope you can hear me and you can see the slides. Okay, so this paper is a joint paper with Clara Smith, professor in Argentina, University of La Plata. And in this paper, basically, we try to provide to answer these two research questions. The first is how to model legal procedures. It's not a new research issue, of course. And second, how to handle priorities in related decisions in legal procedures. The layout of the talk is we will give you the definition of what the legal procedure is in a broad sense. Then I will present syntax and semantics for representing and for modeling legal procedure. And then I will show a couple of actions and non-logical principles for modeling. So what's a legal procedure? I mean, a legal procedure, in fact, is very similar to a workflow. So you have actions, a first action, then you have some intermediate actions and claims and responses by the authorities, and we have a final answer. So in a very short, in a very concise way, we can say that the procedure is a final sequence of actions, and the start is a first claim by the plaintiff, for example. Then we have, as I said, intermediate claims, responses. So we have claims and responses by the authority, by the decision maker, which are called resolution. Then you may have priorities among the options in the procedure. Then we have a last action that leads to a so-called individual norm, which is the judgment. Right. So the language we use for modeling this, I mean, there are other languages that are in the literature. For example, I did myself some years ago with Guido Governatori work where we proposed a language for modeling compliance in business process modeling. And actually, this was an option, but we tried to use a different language. The language basically exploits propositional and dynamic logic in a multi-agent variant of that. And we had some specific constructor that was originally developed in another context for modeling the violation of norms, and that was embedded within the PDL. So PDL in the version we use, adopts these expressions. It's basically a model logic with actions within the box. So alpha IA means that every execution of action alpha by agent I from the present state leads to a state where A is true. And then we have constructors that are some of the user constructor of proposition dynamic logic. In particular, you can build procedures using actions, and then you can have complex actions that are composed by the sequence operator. So P1 and Pi1 and Pi2 are two procedures that you can combine them in a sequence or procedure. You can have a choice. So basically, you have you have that pi1 is one option and pi2 is another option. And then we can have the third option, which is the preference. So basically you have two or more procedures or actions in the simplest case, and you can have a preference ordering among them, and you may have different preference ordering depending on the agent. So you may have a preference ordering for the plaintiff. Then it means that you have pi1 is preferred over pi2 according to the preference of the plaintiff, or you may have that the same as applied to the defendant in the case of the trial, and you can have a court as a preference ordering. So basically you may have a number of different orders for each agent involved in the procedure. Typically in the legal procedure, in trials, you may have defendant, plaintiff, and court. So the semantics is the semantics. So I will not spend time for giving the details. I would like just to draw your attention to the fact is the standard semantics for propositional and dynamic logic. So basically you have a set of possible words, and you have a set of countable set of relations, each of them corresponding to an agent, and that you can have a way for defining complex procedures in a usual way. Then we have also the obligation. I will tell you more about that. And then you have a preference or a collection of strict partial orders over the set of the accessibility relations for the procedures. Then you have the model in a usual way, and then we have evaluations. The evaluation of formulae. So I just draw your attention to how to evaluate an expressional ID, that in the definition or the evaluation of an expression where you have pi1 all times i pi n, which means that you have pi1 as a first option, the first procedure, the first option in the first action preferred by agent I, but then you have pi2, pi3, pi4, pi up to pi n. And basically this is true if and only if you may have choice among them, and you have a preference ordering coherent with the order of the pi or of the different procedures in the box. So it's a very simple extension of PDL, where you basically have a box where you have a preference among the different actions in the box operator. And this allows for capturing the order among options in a workflow. And you basically have a parallel choice, and you may have an order between among the different options in the legal procedure. So, for example, suppose that we have this model, then you are in the state V, then we have different transitions. Transition correspond to the accessibility relation alpha pi, then mu d and beta p and gamma pi and gamma p, and then in this model, this expression is true, provided that you have a preference ordering where alpha p is preferred over beta p, and which is preferred over gamma p, and according to the p preference. You may have different preference order, one for each agent. Then I will show you a couple of reasoning principles. I'm going to finish. For example, we impose a so-called procedural consistency. So it's not possible that if pi1 is preferred according to the court over pi2, and this brings about A, this implies that you cannot have the opposite, the contrary, the opposite preference ordering for any other agent, right? Why? Because if the court establishes that pi1 should be preferred over pi2, then this means that we cannot, this is true and cannot be put in question by the other agents. But except for the court, you cannot have, you may definitely have that two different agents have different preferences. So in other words, in the workflow, the court decides the options, right? Can settle the options in case of opposite views. Then we have also this principle, which basically allows for combining different ordering. So suppose we have A preferred over B, alpha over beta and beta over gamma. And then you have beta preferred over phi, and then we have phi preferred over psi. Then you may compose that you can say that alpha is preferred over beta, which is preferred over, and then you have gamma or phi, and then you have psi. The final criterion, the principle, and then I think I'm going to finish my presentation, is called detachment of obligation. This is meaningful only with weaker version of the PDL, where you can tolerate conflicts. In fact, you may have that alpha is preferred over beta, and that produces A, but you know that there is one possible transition that leads to not A, if the alpha is performed by the defendant, which means that we have a conflict, but you can detach that the other option beta is obligatory. So at the end of the day, you have a way for deriving the obligation, provided that you have a sequence of preferences of the court. And the future work, and then I'm finished. I was mentioning the fact that we can have weaker logics. Actually, PDL is normal model logic, so it's would be interesting to explore a weaker version of this multi-agent PDL with the preference ordering, also the complexity issues. And of course, this work is preliminary in a sense that we just provided an idea, but still we have to check whether this language is adequate for modeling, for capturing several cases, and a significant number of cases of concrete application in the context of AI law. Thanks a lot.
Thank you, Mr. Antonino Rotolo. And we have a question.
Yeah.
I really enjoyed the approach regarding the construction of the presented procedure itself on your paper. Which are your future perspectives in the construction of the application on the proposed machinery? Also, how important the presented principles shall be considered when analyzing the model itself?
Okay, thanks for the question. Well, in fact, one easy way for exploring the concrete application would be to see analogous application of PDL in different contexts. I mean, from the computational point of view, and in developing possible concrete application, there is a huge literature on PDL as applied, for example, on deontic logic, for example. So, in fact, this is a very simple extension of PDL. Well, simple, not technically, I think it would be tricky, but I don't think we are not so far away from the concrete application so far as the PDL was used, for example, in deontic reasoning. So the idea was to use PDL from deontic reasoning into in the legal domain. And this precisely because the mathematical structure of PDL resemble very much to the structure of legal procedures. But so my first question is, we didn't so far too much, but I think there are a number of examples that we can draw from the literature on deontic logic. And this has to do with the first question. Regarding the principle, we provided just a few principles. But those principles are not particularly. I mean, there is one principle that I would like to say cannot be abandoned, which is the principle. The first principle I propose to you, the fact that you cannot have inconsistency in the case of defendant and plaintiff, between the plaintiff or the defendant and the court, because in the machinery we develop, basically the court is a way for superimposing and for solving possible conflict between the preferences of the different parties that are involved in the legal procedure. This is, I think, the only principle that I would like not to abandon. The others are absolutely can be developed. And by the way, would be also very interesting to explore weaker version of PDL, which I think is an open question that I think is not yet explored in the literature enough.
Thank you, Mr. Antonino Rotolo.
Thank you.
Now, I would like to introduce Mr. Livio Robaldo, who will present the short paper with the title Compliance Checking in High-Field I/O Logic via, via SHACL. Mr. Livio Robaldo, you have 10 minutes of speech. Afterwards, we will move on the question. The stage is yours.
Okay, thank you very much for the introduction. Yes, in this paper, I'm trying to present an approach to use reified input-output logic to use it for compliance checking via SHACL. And actually, this is only the tail of a research endeavor that I'm carrying out since more than 5 years. I started at the University of Luxembourg in order to combine natural language semantic, deontic logic, artificial intelligence and law, and OWL RDF. And my plan is to use reification as the main formal instruments in order to glue all together, to use them all together, because all these 4 topics has been investigated in different research. What I would like to do is to carry out all together, to keep a fit in every strand. And on the wake of the transition from machine learning to symbolic approaches for AI, this is you know that explainer artificial AI is becoming very popular nowadays. So this is my contribution to the field, and in particular in the field of artificial intelligence and law. And reification, as many of you know, is a philosophical concept that was firstly introduced by Donald Davidson, who was a philosopher and in natural language semantics, and is a technique that consists in transforming something that is abstract, like a relation, a predicate, into something that is concrete. So basically, we associate predicates with constants or variable in first-order logic on which we can assert other predicates. And reification is a very popular technique, so that nowadays there are several hundreds of neo-Davidsonian approaches to natural language semantics. And the one that I adopt is the one authored by the professor in the middle of this picture, that is Professor Jerry Hobbs, that his theory is a theory of natural language semantics is grounded on a massive use of this reification technique. And so, for instance, in Hobbs logic, we flat everything, and that's the magic word is flat. We transform everything into a flat conjunction of atomic predication. So even if a sentence, John knows that he cannot fly, that in standard logic can be represented with something like this, in which we encapsulate the operator, the model and the Boolean operators within one another. In Hobbs is all flattened in a formula like this that reads, it really exists an event on knowing that is performed by John, and in particular John knows this other event. This is the fact that something else is not existing. This something else is the fact that John is doing a certain action. This action is the fact that John flies. So this is how we read this formula. And as you can see, we reify even the Boolean connected. So the only, this is first order logic, but actually is a fragment of a very limited fragment of first order logic, in which the only Boolean operator is the conjunction. And then on parallel, you know that there are several approaches to deontic logic, and in particular there are approaches that are called norm-based, that try to model deontic logic in terms of if-then rules that state that if something exists, then something else is obligatory or permitted or something else is entailed. So we have a constitutive rule. And the most popular norm-based deontic logic is this input-output logic, authored by my supervisor in Luxembourg and David Mackinson. And so that input-output logic is basically represent the deontic rules in terms of flat set of if-then rules. And again, the magic word that suggests to integrate the two together. This is what I was working in Luxembourg, where I proposed this new logic in which we basically combine the logic of Jerry-Offs with input-output logic in order to move beyond the propositional level, because before that, input-output logic is only studied at the prepositional level, but this is not expressive enough to represent natural language semantics. So my idea, let's use replace propositional logic with the logic of Jerry-Offs and use reification in order to flatten complex operator that in standard logical approach requires embedding of subformula within other operators. Here we flatten everything, and the idea is in this way that we can build a larger repository of norm from existing legislation which is available in natural language. And so here we have an example from the GDPR. This article that is basically state that every personal data processing has to be lawful and is formalized with respect to this if-then rule. This is an if-then rule in input-output logic stating that for every personal data processing, so for every event that exists at time t1 and there is it is a personal data processing between X and Z, and X is a processor and Z is a personal data of the data subject W, then it is obligatory for this processing to be lawful. Okay, everything is formalized like this, and we reach the standard input-output logic with this first-order reification-based approach in order to model more easily natural language statement. And in particular, we want to do them quickly because legislation is huge. We have to build this repository quite in a short time. And this is what I did in another project at the University of Luxembourg, in which I translated the whole GDPR in reified input-output logic together with Monica Palmiani. In this project, I worked with Monica Palmiani. In particular, she developed an ontology that is called Pronto for the GDPR. And then I used the concept of Pronto in order to model the norms in the GDPR. And if you're interested, the knowledge base is available on the GitHub and describing that journal paper. Now, coming back to this is what I did so far before this paper, but as you can see, there is a missing ingredient in which is what I work in now. Because as also my dear friend Guido Governatori always has a kind of morbid pleasure to underline, is that reified input-output logic is a wonderful theory, but it's just a theory. So for now, we only use it to represent them on paper, but we cannot reason because no automatic reasoning currently exists. And it's right. So you can see also my disappointed face on the right. So that the idea is to transform everything, so the OBS logic to implement in RDF in OWL in order to use the reasoner that are already available for RDF and OWL. Because also, RDF models, again, the magic word, into flat knowledge into flat sets of triples, so that there is a direct mapping between the logic of Jerry-Offs into triples in RDF. And so for I guess you know that so this is the interface of Tobriad. We can take any statement in OWL in RDF, and we can reify with the interface, for instance, of O'Brien to represent, to introduce a new variable that, a new constant, sorry, that refer to the event, to the statement, for instance, here in this example, to the fact that in Italy, the minimal age for consent is 14. And In parallel, what I want to do is, besides formalizing GRIOPS in RDF triples, then we have also to model the if-then rules, so to connect the antecedent with the consequent. And for that, I'm planning to use this shackle that is a new recommendation for W3C that will allow me to implement these if-then rules, to implement both obligations and permission and other constitutive rules. And here now, this formula, of course, a bit complex. You can have a look in the paper in which I extract a fragment of Pronto, and then I defined a kind of initial methodology in order to formalize some selected if-then rules from the D'Apreco knowledge base in this shackle. And you can see, for instance, to check lawfulness, to implement the if-then rule, the reified input topology formula that I showed you before, we write this shackle shape in which it requires that if there is a personal data processing, this personal data processing must have the attribute is lawful as true. And this is not something that is asserted. So this is something that is checked. And if when a shackle is executed, shackle tell me that this ontology, in particular with respect to this individual, to this personal data processing, is not valid because it doesn't respect this shape. And this is the way in which we can implement obligations. Okay, because you know that obligations are not inconsistency. So the ontology can be consistent, but still we can have some violations, like if the value of this boolean will be false. And here in an example on how we implement a constitutive rule, because here it says, here there is a rule that says that if there is if the data subject has given consent and there is not this exception now I don't have the time to detail about that, but you find it described on this paper. The exception says that the data subject has not to be a minor. So it basically says if the data subject has given consent as in not a minor, then assert is lawful as true. And then if this constitutive rule triggers on the ontology, this boolean is asserted as true, and then this obligation, of course, that is satisfied. So the ontology is validated with respect to the obligation modeled in terms of shackle shapes. And this is what I'm working now. Any of you is very kindly invited to join me if is interested in shackling reified input output logic. And that's all. Thank you very much.
Thank you, Mr. Livio Robaldo. We have a question. Firstly, I enjoyed explanation and the correlation of the compliance and the deontological reasoning. My question regards the given explanation of the deontological reasoning as we faced the idea that compliance can take into consideration good practices, norms, which don't necessarily bind the parts. How we have to face this possibility when analyzing your model?
Yeah, this is exactly what I'm working now because in the slide I showed an example of exception that are hard-coded in the legislation. What I'm working now is to work on legal interpretations and argument of the several concepts because okay, to check if a data subject is a minor, this is quantitative. You look in his ID, and if he's beyond a certain age, is not a minor, otherwise he's a minor. But of course, there are many other concepts that can be subject to legal interpretation. So we can have, as is written, as is asking the question, someone that can have an opinion and someone that can have a different opinion. Then it is up to the DPIA, to the Data Protection Authority, to take a decision in the case of the GDPR. In case of other other norms, it will be a judge in the court. And what I'm doing now is to model legal interpretation in terms of other concepts and also arguments and all what we need in order to support a certain legal interpretation. And so that we can encode within the ontology also the good practice, the recommendation from the DPIA, and also including the decision. We can, when there is a conflict between norms, there is an authority that is summoned in order to take a decision about the conflict. And the decision is supported by argument. All these can be represented in terms of our concepts. And this is the way I would like to do. And so that you can have a different form of reasoning according to the legal interpretation that you select. Then certain authorities will override other authorities, so the reasoning will be again deterministic. In case we have two authorities that state different conflicting opinions about the same, we will have a non-monotonic reasoning, but this is what happened in reality, and so is fair to model the same also within the ontology by the artificial intelligence.
Sure. Thank you, Mr. Livio Robaldo. And thank you to everyone who participated in this panel, and we close for today. Tomorrow, we will have more presentation from 9 p.m. and 9 a.m. GMT. Thank you very much.